And good afternoon, good evening, good night, and welcome to today's coverage. So, just finishing up things over on Jeff's channel, and very, very shortly we'll get started. So, let me just give Jeff the wave off. All right, I'm all set up. Alrighty, there we go. So let's bring this in. So, yeah, sounds like there was some interesting crap going on today. Where the hell are we? What do I want to do? I want to go to YouTube. I want to pin the links. Thank you very much for that, Rabbit. Place the pin message there. Excellent. So how are we all doing? Let's see. We're putting the links in. Thank you, Digger. Good to see you. Thank you for being here. Stingy, Dance Monkey Dance. Well, it's not always for the dollars. Sometimes it's just because I like to be here. So, Kevin Bipto, mean you mean 115. No, no. So whenever the streams show up, it's going to be your local time. So actually, interestingly enough, when I look at the videos on YouTube from my end, it shows me local time, and it should be showing you guys local time too. So is Block still on? It hasn't been for the last couple of last couple of years. They've sort of like done year on year off sort of thing. There was a bit of a blow up after the last season, as far as I'm aware. I didn't actually watch it though. Um, Mad Cow Mark, hello. D-Way, good to see you. Wax time. It's not that bad, is it? Damn it, the camera is going in and out of focus. What the hell? Mhm. Glitterfart's half here. Fair enough. Ego Luna, good to see you. Thank you very much. Doing better than whoever's blood that is. Yeah, it's a little much, honestly, looking at this though. Tigger's all in. Lovely. Thank you very much. Fossil Steve. You're in before Australia disappears? Oh yeah. Is Chandler coming? That's actually a good question. Hang on. Probably use the where are we? Alright, I need WhatsApp. Up that early, and I'm a dumbass. Well, I've invited him. The Canon focus hunting, surprise, surprise. Yeah. So I thought I turned off the autofocus, which is really annoying. What, the blood looks a little under a pint, don't ask. Mandu got 11 of the strikes removed. Fantastic. That's some great news. Isn't that just the normal amount of blood from coughing after waking up? Look, it's not, so maybe see a physician. Not that we give any sort of legal or medical advice on this channel. But I'll see if I can actually. Can I magnify? I don't think I can magnify on this on a YouTube stream because I want to get a closer look at that blood if I can help it. Mm, get a closer look. No, that's not it. So there's an actual channel called Magnify. That's not what I want. Magnify a YouTube video. How to use a zoom in and out function on the YouTube player. Excellent. Yeah, all right, you stupid video. Hurry up and get to it. Okay, so apparently you can do it. Scroll down to the bottom of the web page. What the hell is turn off the lights? Is turn off the lights a browser? It's a browser extension. Okay. So it turns out you can actually zoom in. All right. All right. Just give me 2 seconds, guys, because if we can manage this, we might be able to get a better look at this, at this bloodstain. Hang on. So what's it called? Turn off the lights. Hell that is. Searching, searching, searching. Apparently it's a thing. So turn off the lights. Add to Brave, add extension. Hopefully that's not going to require me to restart, in which case I'm going to lose the stream. Oh, it's been added. Okay. Alright, so let's see if we can get a better look at this. Options. Really hope I'm not sharing that by accident. Nope, that's fine. Wait, it's buffering? Is it? Oh, that sucks. No, I'll subscribe to that later. Advanced options. Let's say scroll down to the bottom. Shortcut speed, bulb. Okay, hang on, I gotta watch the rest of this video apparently. Video toolbar, show the tomb ball. Okay, so there's a video toolbar. Show toolbar, yep. Zoom in and out using the zoom button. Lovely. Okay. Let's try this again. Oh, except it's taking me back to the damn. Alright. Transfer worked. Oh, lovely. Got a bunch of people coming in. Got the raid coming in. Fantastic. So that seems to have worked. Just give me a second, guys. Basically, I had
door that
had the brilliant idea of trying to use an extension to get a better, closer look at that blood. And I'm hoping this is going to work. Where's the... It's supposed to have added it to the settings. I don't see it in the settings. Oh, I don't care about any of that. What's the zoom button? Advanced options. Color of the toolbar, that's fine. Zoom in or out on content using the zoom button, which is the zoom button. That's not helpful. That is not helpful at all. Ah, interesting. Okay. Hello. I'm just boring the hell out of chat because I decided to try and zoom in on the bloodstain, and it's not quite working for me.
Yeah. Who said it was boring them?
I just sort of assumed. Oh, there it is. Hang on. That
There
doesn't
what is.
appear to have worked.
Enters into the hallway.
Okay. Oop, wrong way.
You need like Blade Runner technology.
Basically.
And then you indicated there was a couch and that you recall a wall.
Couch.
Is the wall and the table that you recalled?
Why is it worked there but not? Oh, that's not pretty.
Yeah, but this DA is so shouty that he was literally giving me a piercing headache because he's just yelling at me.
Something you observed.
I don't see why every time I hit the... Oh, there we go. Hang on.
It is Blade Runner technology. Enhance.
Enhance.
If you found a tortoise laying on his back in the sun, what would you do?
Period.
Tigger, that was not his O face.
I really hope not. I don't need to see that. Okay, look, the quality's not great, but it's there. See, there's some blood here, and then I swear that that's a square there, and it's sort of come across. The annoying thing is, I think it's kind of like it would have been very helpful to have certain individuals comment who had actually been in the apartment.
Mhm.
I mean, surely they're going to bring in somebody that's had some sort of experience with that. I'm annoyed as shit that this doesn't work while it's on full screen. But anyway, it's still interesting to be able to get a zoom in. So
on May 19th when you were in the residence.
anyway, thank you to everybody that's made the jump across. Very much appreciate that. Also, big news: I did hit 9100 overnight, so there's that.
Woohoo!
I haven't actually looked at my tweets, but I did find it. Oh, hang on, just had someone send me something through his Discord. Thank you very much for that. I appreciate that. Someone took a screenshot for me. So let's share this instead. Yeah, see that's the void, definitely. That's way too clean.
Yeah, I guess so.
Um,
But if you look at the place where I thought it was, there's the straight line that's the border, depending, whichever
depends on
side
which
you think
side
it
you
is.
Yeah, because there's a 90-degree there, but theoretically there's a 90-degree there too.
Yeah. Anyways, but I think you're right because that's like perfectly clean.
Yeah. So
It's not a holocaust of blood.
no, it's really not. I mean, look, yes, there's blood around here, there's a little bit down here. It's not anywhere close to what they described.
I mean, they've got to be showing just like massive, like harvest of blood kind of thing going on somewhere, because this looks like a really bad cut.
Yeah.
I mean, if
Like
you went,
this is the sort of
fuck,"
thing where if you nicked a wrong artery or something, yes, you're gonna go and
Yeah.
get stitches. But I tell you what though, I mean, do Americans have coffee tables? I assume you do.
Yes. Yes.
Theoretically, if one's sitting on that mat, I can see someone tripping, smacking the head, going down, and the blood pools there.
Yeah. They said they moved tables and chairs. So maybe a coffee table is one of the things they moved. So
Okay.
they're not being specific about anything. It's just odd. The prosecution so far has just been really, really odd.
Yes, I'm. Americans don't have coffee tables; they use gun cases.
Nice.
Smart asses. No, I was fairly confident. I just didn't want
Yeah.
to.
Tell you what, the easiest way to tick off a Korean girlfriend is to buy a coffee table.
Really?
Yeah, this dude gets in the way. And then you put your feet up on it. It's a table. You don't put your feet up on it. No, that's why you have coffee tables, to put your feet on them.
Flex
Is he
saying,
even
"Is
dead? We don't know. There's no body. He could just, he could be somewhere else.
Yeah, like that's. I really hope that the jury are paying attention to this, because this is a for the amount of blood that is there, I do not see that as being necessarily a fatal wound.
No.
So unless the prosecution have footage from other damn it. Unless the prosecution have footage or photos from other angles, and there's, I don't know, the wall is painted in blood from behind.
Yeah, that's what I'm saying. Unless the camera pans around and it's like a Jackson Pollock painting or something.
That's what I'm thinking. So it's weird. It's very, very weird. Check chat on such on Discord, much bigger capture. Oh, really? I was right about the couch.
Oh, yeah.
Hang on.
Oh, okay.
So let's see if I
Yeah.
can.
Yeah, somebody got thumped on the noggin there.
Yeah, that's what it looks like there.
To me, it just looked like an indentation, but yeah.
Well, I mean, there's a button there, so that I can get the indentation thing. But yeah, that's definitely like red, and that looks like someone's
Yeah.
tried to clean it up a bit.
There's some good splatter. There's some good spatter there. As Flux likes to say, some good blood splatter.
Okay, here's what I consider to be a plausible thing. Someone walks in, trips, maybe. Oh, hang on. Someone walks in here, trips, maybe on the corner of this, maybe they're not looking. They fall, they smack their head, they get up, they sit on the couch, they rest their
Yep.
head on the back of the couch. And that's where the blood's coming from.
And then they're dazed and confused because of the concussion and take out their money and credit cards and put them in the freezer.
Well, that could well be it. But I mean, the wallet's sitting there. Maybe he sat down. The wallet was uncomfortable, so he's taken it out of his pocket. Maybe he's passed out.
I've
We
triggered
don't
Flux.
know.
Spatter, Jeff. Yeah. Just triggering you.
A flux of blood.
All right. It's 4 a.m. for me, and I'm dead. And I got the cleaning lady coming early. I'm going to have to abandon you in your time of need.
That's fine. We've got, what do we got? Another 45 minutes to an hour or so of lunch. So we'll run through some news articles. There's been some interesting stuff that's happened in the last, let's call it 24 hours, including apparently now toilet paper might be giving you cancer. It's always something.
Well, as my dad used to say, yeah, everything will cause cancer. Swallowing saliva will cause cancer, but only when swallowed in small amounts. Just ramble about that all the time. All right, guys. I'll be back for the morning session tomorrow, 9 a.m. Central Time, 10 a.m. Eastern Time. Be there or be careful.
There, Jeff.
Doesn't have one. Oh, I guess you may has a fake one. Anyway, never mind. Bye, everybody.
Nice cock.
See you all. Take care. Have fun. I'll be listening to you.
Fair enough. Sorry, there was a member chat that came through. Oh, and Xcoma dropped 5 memberships. Thank you very much for that. 3 months as the ADA motivator. Wow. Want to say thanks to you as well as Marty and Val. Yes, I'll grift for them. You let me give content, good or bad. Well, yeah, of course. I'm happy to take whatever content anyway. So, okay. All right, guys. So we have some time to kill. Yeah. Well, what type of cancer? We shall find out, shall we? So apparently scientists have uncovered a hidden corridor in the Pyramid of Giza. Banks closing. China on track to dominate development of critical future technologies, apparently. But let's get started with forever chemicals in your toilet. In your toilet paper may be giving you cancer, according to a study. Hang on, I'll just bring this across here. Change the pages so that I can actually read this without it being all over the place. Okay. Your toilet paper might give you cancer, according to scientists. Oh, look, the Canadian teacher with the size Z breasts is being placed on paid leave. Is that time to allegedly kill? Well, experts at the University of Florida, of course it's Florida, warn that your toilet paper could contain toxic forever chemicals, also known as per- and polyfluoroalkyl substances, PFAs, which have previously been linked to certain cancers. Aren't PFAs the things that were like in various like plastics and stuff that they wanted to make sure that kids weren't drinking out of and shit like that for microplastics or some shit? Which have previously been linked to certain cancers and even at low sperm counts. In a new study published in the Environmental Science and Technology Letters on a Wednesday, researchers detected substances in toilet paper known as dipaps. I'm not going to try and pronounce that. They found dipaps. They sound nasty. That was BPA? Okay, thank you. They caught him not wearing his breasts. I did see that. We shall come back to that. Oh, actually, yeah, I'll put a banner up for, caught on lunch. To fuck around. You know, I'll be nice. I'll call it duck around. Time to duck around. There we go. Those precursor compounds have the ability to become different kinds of PFAs, namely a substance called a PFOA, which is potentially carcinogenic. So this may be a small amount of a beat up. Those forever chemicals have been discovered in a multitude of popular items, cosmetics, non-stick pans, clothes, and even children's products, and were most recently at the center of a class action lawsuit involving Thinks period panties. It's too early in the morning for this shit. They need a disclaimer for that. Why do people put PFAs in toilet paper? That makes no sense. No surprise, everything's made with chemicals. How are people surprised that long-term chemicals are bad for you? Good question. I mean, I look at it this way. They put preservatives in pretty much everything that isn't organic. How exactly do you think that preservatives that are designed to keep, ham and beef from going off are not going to have some sort of impact on your body? Like, really? Oh, it's always clickbait. It's always a clickbait article. Breaking news: cancer gives you cancer. Cancer makes you cut the carpet out of your minivan. When he said that, I went and had a quick look on Google search. All I just typed in was work van carpet, and I put it in Google Images searches, and like half of them were sitting there with the carpet cut out of the back, like half of the carpet cut out, and it looked almost exactly like it. So, Tigger thinks they've been trying to sterilize us. It's a distinct possibility. Teflon toilet paper? God, I hope not. Just Dawn blames Bill Gates and the population control. Everything is chemical, even the organic stuff. There. Wait till you see about Hershey's. Fat Man gets angry. Fat Man doesn't care about Hershey's. Fat Man doesn't like Hershey's. It's too bitter. They found bacteria that can eat plastic. About time. Okay, the undergarments supposedly contained potentially cancer-causing chemicals, which the plaintiff claimed posed a health threat to wearers. The inspiration for the toilet paper study was derived from past research conducted by the same team of scientists. They're spending entirely too much time researching our rear ends. Time for the three seashells. Everything is chemicals, yes. Breaking news, everything manufactured today may give you cancer. Sunshine deteriorates plastic technically. True. They previously looked at the presence of PFAs in biosolids. In other words, the solid waste that comes from wastewater treatment plants. So they wanted to get to the bottom of the PFA pollution problem and see if toilet paper was a contributor. Really? That's what you're wasting taxpayer dollars on? With the knowledge of the forever chemicals, with the knowledge that the forever chemicals are used in paper production, they decided to investigate toilet paper. We asked ourselves where the chemicals were used, and one product is paper, said Timothy Townsend. He sounds like a douche. Co-author and professor of environmental engineering at University of Florida. Called it. Is this related to touching receipts? No idea. Did anyone put a link to Mandu? He's got 11 strikes removed. We did that. We have a voice, and we banded together. We can move mountains and make things right. To be fair, dude, I'm extraordinarily happy about that. But that still means that there's 40-something odd there that we still need to fight against. So it's no time to be quiet about it. They found a bacteria living in a nuclear reactor eating the waste. Mother Nature is a scary bitch. Holy shit. Eating the nuclear waste? Wow. Gates has purchased a bidet company. I'm shocked. In a story 2, want your opinion on a valet going through a car. Okay. Alright, give me a minute. Almost there. Toilet paper they concluded comprised 4% of the DIPAP commonly found in US and Canadian sewage systems. But in Europe, that number skyrocketed. In Sweden, for example, DIPAP comprised 35% in France and it was what? In France, it was a staggering 89%. Life finds a way. Of course it does. Leavey FIFO, hello. Are we made out of bacteria? Well, a good portion of our digestive system includes bacteria. But even the recycled toilet tissue isn't safe. It could be tainted with PFAs due to reusing materials that contained DIPAPs. This reduction of PFAs is critical since wastewater, effluent, and sludge are commonly used for irrigation and/or land application. Researchers implored, noting the risk the forever chemicals pose to human health. While North American toilet paper usage is more than any other of countries, according to researchers, the measly 4% representation of DIPAP pollution in the wastewater suggests that PFAs are actually entering the systems via other means. The researchers offer a further understanding of what? The research offers a further understanding of where the PFA pollution comes from. Why do I keep trying to say population? Comes from, but could allow experts to be better equipped to implement changes, Townsend said. And toilet paper isn't the only potentially carcinogenic product in homes. I'm not reading any further because I do not give a shit. Since I don't eat toilet paper and only wipe my ass with it, I'm not going to worry too much about it. No, I think what they're more worried about is the fact that it's going through the system and then being broken down and used on things where we actually use the water. So, but anyway, put preservatives in Huggies diapers. My granddaughter is allergic. Oh, that sucks. So the good people at the toilet paper company. So I don't know if the people at the toilet paper company would be saying that their own products are carcinogenic. That might be converse to their marketing plans. Apparently, Blinken and Lavrov are holding talks. I was going to read that. I thought that'd bore the hell out of people. Mind you, we're sitting here talking about toilet paper. So, what did you say, Stingy? You sent me something. Was that Discord, presumably? Oh, that's a much better. Thank you, Xhammer. I appreciate that. Xhammer has sent through a copy of the photo, but it's had the contrast and brightness change, so you can actually see various bits and pieces of the blood. A quick look at that. Very much appreciate that. So you can kind of actually see where the blood stains on the carpet are. And it does look like there might be a patch over there, although that could just be that could just be something that's like a little was on Twitter? Okay, thank you. WWE superstar Sonya Deville arrested for gun possession in New Jersey. Oh, it's TMZ though. Alright. What the hell? Give me some clickbait to put into the title, I suppose. WWE superstar Sonya Deville arrested for gun possession in New Jersey. I don't know. I kind of feel like I wouldn't mind having a gun while she's around. Having a salad toss is the only way to feel truly cleaned. Became a US topic in 2021, so after I stopped studies. Oh, okay. Sorry, that's popular. Okay. She's fucked. New Jersey gun laws are the worst. Well, let's find out exactly how badly she's. Pretty sweet mugshot. I'd say that's not necessarily a mugshot. I'd say that's well, your opinion on how it happened, though. Okay, interesting. All right, zoom in on this so we can read it. Atlantic City Police Department said in a statement on Wednesday afternoon the incident happened at the Borgata Hotel, Casino and Spa. They said the officers arrived on the scene and they found Sonya Deville cooperating with security. They claimed during the ensuing questioning, the WWE superstar admitted to owning the handgun and did provide them with a permit for it, though it was not valid in New Jersey. The cops said she was taken into custody without incident. I'm sorry, what the fuck? Just been to room on a pothole outside my house. It's been fixed 5 times. Called the town. They said they would reimburse $300. Doesn't even pay for half the wheel, let alone the tire. Fuck. Oh, Yeah, I really wish people would take responsibility for the potholes. A couple of years ago, when I was driving my car and, I was young and stupid, so I had a low slung, um, base model BMW. Not that that was, like, a present to myself. I worked really hard and earned that, so don't think that I'm, like, flexing or anything. It was a piece of shit car. I just really liked it because it had a sunroof. Um, but because it was low and it was raining and I hit this enormous pothole and the rear wheel just shattered. And because it was a state road, I had to apply to the state authority for compensation. And between the rear rim and the tire, it was going to cost me just over $1,600. And because of the damage that it had done to I think it had done a little bit of damage to the axle as well. And they basically said, "Oh well, because it's a state road and we're a state authority, we're allowed to deduct the first $1,400 worth of compensation for it. So you'll go through this entire process and you'll get about $150 back." And I was like, "Fuck, it is not worth the time and effort." It's not the mugshot of being swindled. Of course, fake boobs are fake. What trial are we watching today? So today we have the Zachariah Anderson trial. Actually, I will just double check whether or not the Law and Crime Network. Because if you'd rather watch the Triple X trial, I'm happy to play that instead of boring you with news articles. Although the audio is never great on that channel. And they're looking at a map of some sorts. Don't accept concealed carry from other states. Okay. Concealed carry in every state and any law restricting that right is unconstitutional. Mhm. Aluminum wheel shattered. Gone down. Yeah, I hit it hard. Was you got from by the states? Yeah. Sounds about right. According to our state, they kept the price at 300. So never mind if you have custom wheels like me. If you have a brand new car, you're basically fucked too. Yeah. It's fucking messed up, honestly. Okay. So she admitted to having the handgun and had a permit for it. So was she carrying it on her at the time? She was arrested for gun possession in New Jersey last month after authorities say they found a firearm in her vehicle that didn't have a proper New Jersey permit. According to the court documents, the incident happened on February 19 at Atlantic City, when our sources tell us that the valet discovered the weapon in the glove box and called the cop. What the fuck?
What the fuck is this piece of shit?
No, that's not okay. That is not okay. Valet was rummaging through a car to steal shit, came across a gun, called the cops, search will be suppressed. It fucking well better be. Emus, not ostriches. One of my favorite quotes is you can conceal carry in every state if you're not a pussy. That's some bullshit. Police arrived on the scene and arrested DeVille, named Daria Bernardo. Short time later, and court records show she's since been charged with one count of unlawful weapon possession of a handgun without a permit. Sources close to the arrest tell us that DeVille got the weapon for personal protection after a 24-year-old man allegedly attempted to kidnap her during a terrifying home break-in in Florida in 2020. We're told the gun is registered in Florida, but not New Jersey. Court documents show the 29-year-old is due in court for a hearing on the matter later this month. Okay, let me just float something. If various states require you to have permits and that sort of thing, and the right to bear arms is covered at a constitutional level, why are permits not equally valid across every state? How is that not a federal issue compared to a state individual issue? Exactly, the Second Amendment shall not be infringed. Um, like that's strange to me. They take my gun and give it back to me after I arrive. Okay. No, that's why I'm wondering why there's no registration as a whole. Like, I mean, because permits are unconstitutional. No, I figured that. States' rights, but okay. Strange to us too. Okay. All right. That's a Bronco question. Fair enough. Been asking that for decades myself. Oh, there you go. Yeah, so the dude looking to steal shit snitched, apparently. Probably looking for his 5 seconds of fame, and yet his name didn't even make it into the. I can kind of understand why she's carrying a weapon, though. Oh, what was that? Oh, okay. That's Jeff for tomorrow. I was wondering what that was going off in my ear. Okay. Shit. Where did big tits go? Sorry, big fake tits, I should say. I want to see exactly what I want to see what the update is on that. Ooh, God, no. I don't want to listen to that. Canadian teacher with size Z prosthetic breasts placed on paid leave. The Canadian high school teacher who wears massive Z cut prosthetic breasts in class has been placed on leave after the post revealed that she rarely wears them outside of school. The Halton School District confirmed that Oakville Trafalgar High School shop teacher Kayla Lamo was put on paid leave on Tuesday. Yeah, they've taken breaks, so I'm basically just pissing away the time at this stage center. Don't worry, as soon as it's back on, we'll be back there. Uh, Actually, be a good case to get these laws struck down as long as she is willing to fight. She makes a great appellant. Well, there you go. In New Jersey, it's against the law to carry legal gun in the state unless it's from New Jersey. She'll go to jail. You reckon? Yes, Winter Sailor. It's very much a guy in a wig. He has fake boobs. How? I'm still wondering how he got away with it for as long as he did. Honestly, it's surprising that they didn't want to touch it. Well, no, it's not surprising they didn't want to touch it, but they didn't want to have any interaction with him until it was proven that he wasn't wearing them outside school. Like, as far as I'm concerned, you shouldn't be afraid to call people out just because you're worried about wokeism and all that sort of bullshit. New Jersey should be bulldozed. Gender fluid is claimed by so many, so what? Yeah. While not currently on active assignment, the teacher remains employed with the Halton District School Board, according to spokesperson Heather Francie. Lamo's suspension comes after the Education Minister, Stephen Lecce, and Halton Region MPPs Natalie Pierre, Stephen Crawford, and Effie. How the hell do you. Trianaphiliopoulos. Not even going to try that again. Rebuked the school board for having abdicated its responsibilities by failing to put the interest and safety of the students first. Too fucking right. About time. Like, it's not just the fact that it's the size Z breasts, it's the massive nipples as well. That's just disturbing. One mother named Lynn called the school board on Wednesday told the school board that forms of identity and expression presented in the school environment must be scrutinized against the child's safeguarding practices. The board has remained largely quiet about Lamo, while parents have raged for months about her wearing the prosthetics in front of students. Photos and videos taken in school have shown her wearing tight clothing with large nipples protruding under the fabric of her top. The controversy has sparked numerous threats of violence against Lamo and school officials. Board of Education meetings have descended into chaos as it attempts to address the issue. There shouldn't have been any chaos. It should have just been dealt with. The knockers causing cancer. Pancake nipples are so freaking hot. Grab some syrup. Jesus, Jonathan. uh... Trans fake mood milkers. Yeah. Just got the notification that you're live. You're behind schedule, but better late than never. No worries, Red. Dude thinks he's Mrs. Doubtfire, quite possibly. I'm so ashamed for it to be from Ontario. That sucks. Hey, Crystal. School board won't do anything because they fear being attacked by the woke mob. Yeah, but it looks like now they've got a legitimate reason to stand against it, or at least they've been. It's someone's gone over their head, and they've basically been backhanded over the, or smacked up the back of the head, or however you want to look at it, by the education minister, and they've been given deniability. So hopefully things will actually move forward now. Yes, of course he's doing it to get attention at this point. I think a lot of what he was trying to do is double standards. He was accused of misogynistic comments, I believe, so it was trolling. Wouldn't shock me. He said that they were real in an interview, saying he had some sort of ginormous deformity. 80% of Toronto should be bulldozed too. There he is. That's him outside of school. The saga gained international attention and came to a head after the Post revealed last month that once outside school, he often ditches the breasts, wig, and makeup and appears as a man, which sent shockwaves through the district. Post photos show a dressed-down Lamo wearing men's sweatpants, sneakers, and a puffer vest, with no signs of her breasts, makeup, glasses, or wig, a get-up that her neighbour said she wears extremely infrequently. She insisted in a sit-down with the Post that the man in the photos was not her, although she admitted that she could not prove it and denied wearing prosthetic breasts at all. Yeah, you're right. This is not good for people that are legitimately transgender. Not that I'm saying that he's not. I'm just saying that if he slash she slash they them, if they legitimately only do this at school, then it's purely for, yeah, and that it's purely to be doing it around kids, and that's not okay. They're shocked at it being a man, but not a fake woman. Lol. I know, right? Those damn Canadians. Taking a class this semester called Cultural Sensitivity and Equitable Teaching. Oh, fuck. Best of luck with that. Yeah, he identifies as a man after work, presumably because he faced some sort of, I don't know, discrimination or some shit at school. So, prefer to use it as a pronoun as at that point it is no longer a person. Okay. Cross-dressing is not trans, says the internet. That is true. I do fall into that same sort of category. You can be. There's different delineations in my mind. You can be a bloke that likes dressing in women's clothes. That does not necessarily make you gay, because you can be doing that while you're screwing a woman. That being said, that doesn't necessarily mean that it's any less uncomfortable for anybody else to be thinking about. And this sort of shit should not be going on in school anyway. Being transvestite is not being trans. Yes. Transvestites is not as transvestite is not the same as transgender. No, I do not wear a skirt. I always wear pants, thank you. Last in the class, bloke in the... Oh, you can't find a rhyme for that? Let me try. Last in the class, a bloke in the ass. How dare they discriminate how he chooses to present? Canada's so bigoted. Cross-dressing is a perversion, says the internet. Yeah, but everything. Yeah, and you know what? You should believe everything that is said on the internet, because everything is true. And I'm sorry, but apparently straight sex is also considered a perversion. So I don't really put much stock in that. So when he's dressed as a man, he's cross-dressing. Real men will wear kilts. Why is it always a man pretending to be a woman? Because they're trying to... Wait, what? Oh, come on, just load. Oh, shit, are we back in court? We are too, sorry.
That the detective
Sincere apologies.
did not have the opportunity to ask during that interview.
And
Let me,
Sorry.
Yeah, apparently spent more time talking
Sorry.
with voices than I thought we
and then
did.
also, were there any other opportunities to interview the defendant? So I don't intend to go any further than that. But again, we're talking about this avenue of what was the investigation. Certainly an hour and 29-minute video or interview does not, as the court is well aware from its long experience, is not an amount of time to cover all topics that would be necessary.
No, but mostly because Barilio is
believe that is the
litigious,
line.
and
I'm
I don't
asking
need
the
that
court
in my
if I have
life right now.
permission to go that far and no further.
Go ahead.
Thank you, Judge. Asking why there were other questions that should have been asked that weren't, and then that they weren't able to have the opportunity to question him again is encroaching on the fact that my client asked for a lawyer, and that was why the interrogation concluded. So asking those questions, implying that there's more and that my client chose not to speak, is directly going towards his right to remain silent at that point. So I would argue that the state cannot ask those questions of, oh, would you have asked more questions if you would be able to? Because the inference there is that they weren't able to because he invoked his rights, and that they didn't get to talk to him again because he invoked his right to silence.
And again, I only bring this up because of the issue of the adequacy of the investigation, right? So there are natural limitations.
I believe it's a birthmark.
I'm aware
right?
I cannot go any further, so counsel indicated, what I can't argue, and I absolutely agree. I can't say here's why or in any way imply that in argument or in question. But I do think it's a proper question right at the line. It's a proper question to ask as I described to the court.
Well,
Oh, hang on, we're missing something here.
the problem is you're lobbing the ball over into their court and saying, did you have an opportunity
As you
to ask more questions?
as you often are when you go to the line. Right? I mean,
Right,
that's the
but
nature
we don't
of
want to do anything brazen.
Right.
And
He said it. He said the word.
You're lobbing the ball onto their side and making them respond.
Oh,
And
sorry.
they're
Got the
kind of
subtitles.
handcuffed. If the answer is
Hang on, where are they? They were on.
he lawyered up. And of course, then you're in the forbidden woods.
I've turned the subtitles on. They're not
So
putting them
really
through for
the
some
analysis,
reason.
though, is am I asking a question that comments on his silence or comments on his invocation, right? So the court is right. It has some consequences, but the question is the question one where I am calling on the officer to indicate in some fashion that he has invoked his right to silence or to an attorney? I would suggest to you, as suggested, the question does not do that. Of course, I can't argue. I apologize.
So yeah, a very, very tight interpretation.
Yeah,
You
no,
could-
I'm fairly confident that
make
they're
that,
using Court
claim,
TV's
but
stream from the Court
the
TV
problem, as I
website, so we won't have
say,
access
is
to subtitles, unfortunately.
You're forcing the defense into a position where it has to come up with an answer, and if the answer is that he had talked to a lawyer and whether he talked to a lawyer or not, he simply decided not to discuss anything further with the police, they can't respond. And so it's sitting out there. And if during the remainder of the testimony, a juror
Actually, that's a good
is
point.
saying-
Jeff has subtitles.
after hearing the remainder of the testimony,
Oh,
a
unless
juror
maybe
is
they're playing it on Court TV as opposed to Law and Crime. Give me a minute.
all these years since this, and the defendants never told the police anything more, then you're definitely, what is the name of the case? I think it's Champlain.
Yeah, no, they're still showing the
Chambers,
murder
one of
trial.
those.
I don't get it.
Not one of those, well, whatever it is, the rule is very clear that there's no comment permitted by the prosecution on the failure of the defendant to address the case.
That's a bright line rule, and I'm aware of that.
Okay.
Now, what has happened is the defense has lobbed into the state's I mean, let's be sure we talk about this fully in the venting of what you described. There's been an opening statement. It is certainly said detectives made a number of poor choices here, right? I mean, that is the clear thing, right? So a reasonable juror hearing the 25, perhaps 30 questions that officers did ask would very reasonably, based on the argument made and the ball being lobbed into our court, say, well, why the heck didn't the officers ever address with the defendant why this van is cut out, a third cut out, or any other thing that the state suggests is of significance here? Why wasn't that ever brought up to the defendant? That sounds like it's the same pattern of they didn't test fingerprints at X, Y, and Z. They didn't search this part of the woods. And we're left with no way to respond because, in fact, those questions would have been asked or certainly could have been asked had there been a different posture. Now, again, I am absolutely conscious. I am not allowed to bring up an invocation of either silence or the right to an attorney. But I think that the simple declaration by the detectives that they would have asked that they would have liked to ask additional questions and that they never had an opportunity settles the matter. It creates a situation where the prosecution is not going to be
I'll try and fix the audio.
penalized
Give me a second.
based on the argument made by the defense for any question that the juror wishes a detective would have asked the defendant. I mean, otherwise I'm left without an explanation, right? Because the explanation is a legal and constitutional one. So I'm tied. If the court says I can't even reach that line, I have no way to respond to a juror concerned that in the context of what's been said, what the heck, why wouldn't a detective ask that question? He asked 25 others.
First, about the ball being put back in their court. The ball's in their court. They have the burden. It's never that we've shifted that burden here. And second, as far as the answer to a question of why weren't you able to answer these questions that you would have, the only answer that a detective or any witness can give is that we weren't able to continue questioning because he invoked his Miranda rights. So there's no leeway here.
No, it's not good enough for sure.
It's not the defense's fault if the state doesn't have any other evidence to support its claims. It's their job. The case that deals with this issue is Griffin versus California, 380 U.S. 609. And in that case, and I'm just going to read, says that a comment to the jury by a prosecutor in a state criminal trial upon a defendant's failure to testify as to the matters which he can reasonably be expected to deny or explain because of facts within his knowledge or by the court that the defendant's silence under those circumstances evidences guilt violates the self-incrimination clause of the Fifth Amendment of the federal Constitution as made applicable to the states by the 14th. There is, and also this concept that I'm going to ask an officer, well, why didn't you ask my client that? Well, obviously, I'm not going to violate my own client's constitutional rights. I would not ask a question of that sort. The questions that the state have outlined are clearly across the line of what's permissible under a constitutional lens and pursuant to Griffin versus California and my client's Fifth Amendment rights.
The case does not stand for the proposition that I can't reach this place that I am. I've been very careful in the litigation here. I've approached the court first. I'm doing the exact opposite of commenting on the defendant's silence. I'm asking the court for guidance on how I can structure a question to a detective that allows there to be no comment on silence, but also allows a fair presentation of this evidence to a jury in the way I've described. Again, the only other option we're left with is a jury wishing there were answers to other questions, knowing a series of questions have been asked, and left with the implication that officers are not competent enough or are too lazy to ask these additional questions. Now, again, I don't mean to comment on either of the two things. I simply ask the very structured questions. I believe I'm doing it in the appropriate way. It's the exact opposite of the case cited where a prosecutor actually comments on this. I am trying to be careful in my litigation here and ask the court for guidance to be able to ask those 2 questions. Did you ever get a chance after the interview on so forth? Did you ever question the defendant again? And then the second one is, were there other questions that you would have desired to ask based on your investigation?
No, absolutely not. Do
And
not
of
allow
course
those.
You did the right thing by bringing it up first.
Sure.
But I to the extent that you ask me for guidance as to what you can do, that I can't do. I can't give you advice as to how to
Well, I've told you
present
this,
your case, and I've made it pretty clear what you can't do.
I've told you the 2 specific questions I intend to ask. So I think the court can probably help me with that.
Well, but definitely the second one is totally out. What was the first one?
The second one is, did you have any other opportunities to speak to the defendant?
No, that's
Okay.
that's
No.
So the first one was, are there other questions that you desired to ask of the defendant that you did not ask?
Don't
Don't you dare allow that,
You're
Schroeder.
complaining that you're left without a way to somehow effectively cover this. That sometimes that happens. And sometimes it happens because of the Constitution. But it's what it is. And I don't know if can you cover something like that in your argument to the jury and say,
I imagine that is more problematic.
I didn't tell you what I was going to do to raise your hair. Or those events. And I think I'm actually going to stop and not do it, but there's at least one way I can think of that I would at least be tempted to do. And well, leave it at that. I don't think you're without a way to buttress the police investigation. But the way that you're explaining it to me is not one that I think is one that I would sanction.
That's a new one,
or
Patty.
even permit.
Okay.
No.
Okay. Thank you.
Okay.
Do we have any prior record that we have to work out? It doesn't have to be.
I was going to say that should not be being heard. Thank you, Rabbit, for the 5 gifted memberships. Very much appreciate that. Congratulations to Dawn Marie, Isaac Brew, Wholesome Gabagool Art.
Further late jurors?
Before I go, Carmen Clayton, we are everywhere.
Everybody's here on time.
Who is calling?
Would you come down, please?
Oh, he is. Might be a mistrial. It'll
Anthony
lead to
Ward.
dismissal of the charges. Can always hope. This guy makes Bingo look like a pro.
You have a divorce trial when? When?
Who's getting divorced? Did he just say one of the prosecutors is getting divorced and they've got the trial next Tuesday?
Well, another state is 9 miles away.
Yeah, he has some serious issues. And yes, he was definitely pouting. He was not happy with that loss. And there's no way in hell that those two questions should have been coming through anyway. So inappropriate. Oh yes, the police didn't do their job properly, so we're going to ask these questions on the stand and put the seed of doubt in the jury's mind that there was additional things.
Enjoy the day.
It's a damn good question, Tweety. I got no clue.
No, I haven't checked the weather forecast. Are they still talking all kinds of ominous weather this afternoon?
Oh my god, just leave it up or take it down.
Oh, it's tomorrow. Okay.
For Kenosha, they were wavering somewhere between 1 and 5.
Not disagreeing with you on that, Jim.
I thought there was a chance it was all going to be rain here.
They started approaching, and then they said it's worse south of us, but with the slightest change in wind. Meteorologists are my favorite.
Well, you're being too harsh. They've correctly predicted 45 of the last 3 snowstorms.
Judge, currently the Weather Channel is saying snowfall around 1 inch for whatever that's worth.
Hey, this is Wisconsin. Huh, I won't even notice. All right, Mr. Gravely.
Thank you, Your Honor. Detective, when last we were here, I was about to again begin to ask you about the interview that occurred on May 19th, 2020, regarding the Zachariah Anderson. And again, you've identified Zachariah Anderson as the individual here in this courtroom. Is that correct?
Correct.
And you spoke to him for about an hour and 29 minutes in total.
Yes.
And that was a question and answer format.
Yes.
And did it include the defendant also asking some questions during some of that period?
Yes, he had some.
And did you provide him any nourishment, any food or water?
We gave him water, which he requested a couple of times.
And ultimately, that interview then concluded, if I got this correct, at 12:18 a.m. Does that sound right?
Yes.
Okay.
I believe this is still
So
the,
in the time period of that interview, did you
I should have written down
provide
his name while I was
any
on just
threats or promises to the defendant to get him to provide any information?
No.
Did he provide that information? Did he answer some of the questions you asked at least?
Yes.
All right. And did you at some point have occasion to talk about a phone that purportedly appeared to have ended up in a car driven by his ex-girlfriend, Sadie Beecham?
Yes, I did.
And was this something that you asked him about?
Yes.
And what do you recall him telling you about whether he had intentionally placed that phone or some other explanation?
So Zach had said, Mr. Anderson said that Ms. Beecham had dropped the kids off at his residence. And during the course of taking his son out of the back seat, he believed that this cell phone may have fallen out of his pocket, or his son may have grabbed the phone and put it in the car.
What, if anything, did he say about whether he on purpose hid that phone under the car seat?
No, he said he
he's lucky
didn't
I couldn't
realize
get the branding
this
soon enough, the lane thing.
until after Sadie had left and he realized the phone was gone.
What, if anything, did the defendant say about how he managed to figure out where that phone was then located after it was in Sadie Beecham's car in that location?
Mr. Anderson said he contacted the phone provider, Cricket, and Cricket told him that the phone pinged in North Kenosha.
What, if anything, did the defendant tell you about having loaded an app on his electronics that would, in fact, trace the exact location of that phone prior to losing the phone? What, if anything, did he tell you about that?
He said nothing about it.
What, if anything, did he offer to you regarding indicating that on the date that Sadie discovered that phone, that he actually had accessed that app to be able to discover where the phone was using the app in his own electronics? Did he mention any of that to you?
He said nothing to that.
No,
Did you ask
Thanks for being
what, if anything, did you ask the defendant about having been to Sadie's home during the early morning hours over the last few weeks? Did you ask him that question?
Yes, I asked him if he had been to Ms. Beecham's house at any point during the early morning hours.
Let me
It was
let me just stop you for a second. And did they live together at that
The
time?
defense isn't the one.
No.
The defense.
And per your investigation, was he welcome at
just
that
not-
house in the early morning hours?
No.
Okay. So when you asked him that question, it was a specific
There's a
question
version on
about
Samsung
in
there,
that
too.
context. Is that true?
true.
And what did he first offer up to you as his explanation for any for a visit to her home in the early morning hours? What was his first explanation?
He said there was a time when he had picked up a couch late one night and he was dropping the couch off there late.
Go ahead. And did you then repeat the question. Ask him again and ask if he had had his kids along on any occasion. Did you ask him that?
He did initially.
Yes, I asked him if there was
Like,
another time
the
when
defense
he had
picked
his
up the mic and
children
dropped it in
that
front
he
of him.
went there.
And
I
then
think
did
he
he
told
offer
him.
that he had?
Yes.
Could he remember the date? As best you remember?
No.
And which children did he claim he had taken along with him?
All three of his children.
Okay, so he has a couple of twins who are younger and then a daughter who's, 10, 11, 12, something like that.
Correct. He said he had taken his daughter as well as the two twin boys.
Was it at night?
Yes.
Did he indicate why he felt a need to take his children? He had the children with him. Is that what you're saying?
Yes.
So why did he indicate he felt he had a need to take his children when Sadie Beecham would have not been caring for the children?
So he
was caring for the children?
First, he said there was a car in the driveway, and then he stated he had a premonition that there was someone at her house.
And at that point, were these two in a
Sorry,
marriage,
what?
as far as you know?
No.
Were they in a situation where any of the children would be at Sadie's home?
No.
Okay, so he and the children drive to her home per his report. Is that right?
Correct.
And at what does he indicate happens when he is at that residence?
So he said when he pulls in the driveway, there's a vehicle there with Colorado license plates.
And let me stop you. Does Rosalio Gutierrez have a Colorado license
damn
plates
good
on
question,
his
Jim.
vehicle that you saw at
I'm
his
not
residence when you discovered he was
I probably would have
gone?
been jumping up and down by
Yes, he's a
now.
white Ford Explorer with Colorado license plates.
Okay, so what else did he say?
He said he got out of the vehicle and looked through a window.
Look through a window through a window at the vehicle?
Looked through a window at the house.
Okay, and whose home is he speaking of?
Sadie Beecham.
Did he say he saw some things inside?
Yes, he said he saw them on the couch.
And did he indicate whether any of the children were also involved in looking in the windows?
Yes, he said his daughter came out of the car and looked through the window.
And did he indicate that he had that was something he was a part of in some fashion?
He had told me his daughter did this because she wanted to.
And did you at some point ask the defendant whether he recorded any using any devices of his at Sadie's residence when he and his daughter were there looking in windows?
Yes, he denied recording anything, although he did admit to having a cell phone in his possession at the time that he used the light on because it was dark.
Shock horror. He had a
And
phone
was it
on him.
his regular cell phone?
I'm going to object as far as foundation.
Did he?
Yeah, it's fine.
I'll ask again. I'll clarify. Yeah. Did the defendant explain to you that he had more than one phone that he was using on a fairly regular basis?
Yes.
Okay.
Well, you never told
And
the
did he
cops,
describe
shouldn't you?
one
You
as
asked an
his
attorney to
primary
space me out.
phone and another as
Absolutely.
his secondary phone?
I guess, Judge, I've been lenient, but all these questions have been extremely leading. So I'm going to object to leading and ask, and that it not be leading.
I apologize. I was just doing it in this situation. I was just doing it because it was a foundational question. So, but
Oh
It's
shit!
just been
You
like
knew
5
exactly what
minutes
you
of
were doing, and it
foundational
was
questions
leading.
then.
Foundation or not, you should have been asking them open-ended.
They are tending towards being suggestive, so if you can rephrase.
what do you recall about whatever he told you about these phones?
He had two phones, one
There
he
you go.
used primarily for calling.
And what, if anything, did he say about doing any recording using any devices on this particular date?
He did nothing.
he
No
talked directly to the
recordings.
opposing counsel.
At some point, did you begin to ask questions regarding
If Martin Short's
new boyfriend
if Martin
of,
Short lookalikes in
Sadie's?
the background, I'm going to laugh my
I did.
ass off.
and what, if anything, was the defendant's discussion with you when you first brought up this individual in terms of things like whether he knew his name, a general discussion of what he appeared to know about.
I'm just going to try and fix up my camera. I'll still be here.
He said he found out about the new boyfriend through his daughter, as well as a grandmother. Grandmother had shown daughter a Facebook profile of this subject, and that's how he found out who he was. I asked him what his name was, and Mr. Anderson said,
Mr.
I
Anderson.
believed it was Junior, and that his last name started with a G, and that he was a Mexican.
And what, if anything, did the defendant ever tell you about the fact that in his own phone, that was a racist slur? Well, let me stop. Okay, so did the defendant ever reveal to you that he actually did know the full name of the individual that Sadie was dating? Did he ever tell you, yeah, I know the guy's name?
Pretty much.
No.
That does seem to be what's coming out of this.
Now, at some point, did you begin to focus on the vehicle that the defendant may have driven at various times that you were interested in?
Yes.
And what vehicle specifically were you interested in regards to your interview with him?
I asked him about the
To be fair, sir, you should probably be asking the mom.
Chrysler minivan that was parked in his driveway.
And what do you recall about the defendant's response when you first suggested anything to the effect that he was a driver of the van?
He described the minivan as either being black or blue or something, and that was his words. He also indicated that he doesn't drive it much, and that
Do you reckon if I put a tag on this video?
it's basically
just
there
like
for the
Nick
taking.
Ricader, Joe Neiman. You're going to
Did
get
he
a bit
describe to
boost in
you
videos.
that he drove a different vehicle, if you know?
Yeah, the Audi. He mentioned the Audi.
Okay. And what, if anything, did he say about whether he had ever been in Kenosha at a time that Sadie had been there?
He said he couldn't remember the last time he was in Kenosha.
Period?
Period.
Okay.
He did mention that he plays board games with his brother, and they may have been in Kenosha, but he didn't recall ever being in the city of Kenosha.
And in connection with being there because Sadie was there, what, if anything, did he tell you about that?
I'm sorry, repeat that?
Yeah. Did he indicate that he ever followed Sadie down here to Kenosha?
No.
At some point,
Is this
did
some
you
newfangled hearing aid?
direct your questioning to whether anything had ever been taken from Rosalio Gutierrez's vehicle, that truck?
Yes.
And what, if anything, did the defendant tell you about whether he had taken any items from the vehicle of Rosalio Gutierrez?
He told me to spare the accusations. He's already been accused of this, and that it didn't happen.
And what, if anything, did the defendant offer to you that in one of his phones, there is a screenshot of, in fact, a registration document regarding that truck?
Nothing.
What, if anything, did the defendant say to you regarding whether he had any jealousy towards the fact that Sadie had a new relationship?
He had admitted to me that he did have some jealousy, however, spun that and said that Sadie was the one that was jealous.
Oh, yeah, I did that deliberately because people were complaining I was talking over the court.
And did you, what, if anything, did you ask whether these two individuals, meaning the defendant and Rosalio, whether he had ever seen Rosalio?
I did. I asked him how many times he had seen the subject he was referring to, and he had told me it was just the one time when he peered into that window.
So what, if anything, did the defendant offer you about about his phone being in Kenosha on May 13th, which would be a different time than the time that you are speaking of? What, if anything, did he offer about that?
Nothing.
What, if anything, did he offer to you regarding the idea that he was texting
I would very much like to see
Sadie,
them do that.
directly quoting things that Rosalio was telling Sadie in Rosalio's residence on May 13th in Kenosha?
He said nothing.
So as to May 13th
No,
in
Crystal,
Kenosha,
it's not hearsay.
what, if anything, did the defendant say
Because it's
at
what was
all
spoken to
about
him.
that in the context of perhaps being a second time he had seen Mr. Gutierrez?
It was never mentioned.
At some point, did you bring up an individual named Steve Lentz, or did the defendant bring up a person named Stephen Lentz to you?
Yes.
And just so we understand, who is Stephen Lentz in this investigation, if you can tell us?
Stephen Lentz was identified as a friend of Mr. Anderson, a neighbor. At one
Anderson.
point,
I've got to get that as a
Mr. Lentz actually lived in his backyard in a tent at one point. Mr. Lentz's mother lives right down the street from Miss Beecham, about 400 feet down the road on the opposite side of the street.
From where Mr. Lentz, and was Mr. Lentz residing there in April and May of 2020?
Yes, he was.
And from Mr. Lentz's then residence, could you see any portion of the house or a place where Sadie Beecham was living?
Yes, you could see the driveway of Miss Beecham's residence.
And were you able at some point to obtain a phone number from Stephen Lentz?
I did.
And just for purposes of us clarifying, was that phone number based on the records that you reviewed, et cetera, 414-378-4935?
Yes, I believe so.
Okay. So let's go back to the interview with the defendant. At some point, Stephen Lentz came up. What do you recall about how he came up?
We went back to the idea that he had a premonition someone was at the house. Ultimately, Mr. Anderson told me that there was a guy named Stephen Lentz that would call him and tell him when vehicles are in the driveway. But he also stated that he had never told Mr. Lentz to provide this information.
And what, if anything, did the defendant ever tell you about communicating with Stephen Lentz, asking him on occasion if there were cars in Sadie's driveway?
Nothing.
Now, when you spoke to the defendant, what were you telling him that you were questioning him regarding?
I told him we were investigating the stalking incident.
Ooh.
Did you tell him who the people were who you were
Vegas that killed a
suggesting
reporter?
he
Is
might have
going
been
to appear
stalking?
pro se.
Yes.
Okay.
Ooh, what happened there? Oh, that's funny. That's funny. For anyone that can't read it, that's...
He had been
oh, there we go. Never mind. Still funny.
arrested. Did you were you having this discussion with him? So, if I understand correctly, there was a contact with law enforcement, and he got arrested in Mequon.
Correct.
And then about how long after that arrest in Mequon do you estimate it was before you're having a conversation with him about stalking Sadie and this other individual?
I can try and use the equalizer. I don't know what it's going to do to the audio, though.
I don't know the exact amount of time, but probably 3 or 4 hours later.
Okay. And
Oh, stream unavailable. Why is it saying that?
at some point, did you focus on attempting to figure out where the defendant had been on the day of May 17th, 2020?
Yes.
Okay. And if you can briefly say why was that your focus as opposed to the 16th of May or the 23rd? You know, what was the reason why you were focused on the 17th of May in your questioning of the defendant at that moment?
From what we knew at the time, that was the last communication with Rosalio was on the 17th, and we believed that that was the day that the incident occurred from what we knew at that point.
And did you believe that also to be in the evening hours?
Yes.
Okay. So you had a general amount of time that you were focused on because that's where your investigation was at that moment.
Correct.
So do you remember focusing on that with the defendant where you asked him, you know, so please tell me about what was happening on the 17th of May?
Yes.
Okay. And again, you're on the 19th of May now?
2 days later, yes.
So you're asking him on a Tuesday what happened on that Sunday during the day. Is that correct?
Yes, day and night.
Okay.
Yep.
And so what do you recall about what he offered to you first in terms of his activities on Sunday?
So he said he was with the children during the day, and Sadie came to pick them up. And
Did he
then,
tell you in general when that occurred? In general?
I don't recall.
Okay.
I wanted him to keep going with the rest of the remainder of the evening. And he said he thinks he went to a girlfriend's house named Christine.
Okay. Did he eventually offer the last name of that girlfriend as well?
Yeah, Christine Remsburg.
Okay. So did he indicate that when he went there that
Yes,
he
he's
believed
been charged with stalking as well. Oh, come on. Stupid war crime. Play, Damien. Play. Fuck you.
spent the night? Was that his
Okay.
initial discussion with you?
He never. He was very wishy-washy on what he did that night. He said he may have been there. He may have stayed the
Wishy-washy like the
night.
prosecution?
Wasn't really sure. Yeah.
And did that wishy-washiness come when you pressed him and said, dude, you don't remember what happened 2 days ago? Is that when that happened?
Yeah, I was unable to get anything concrete as far as what he did that night. And he was just throwing out things. First he said he stayed with her. Then he said he may have called her. He doesn't remember. He just never gave me an answer.
What, if anything, did the defendant say about ever having an in-person interaction with this person, Rosalio Gutierrez? Did he offer any, what, if anything, did he offer in regards to that?
Nothing. He said he only saw him that one time, which was through the window.
Well, what, if anything, do you recall about the defendant offering up something about Sadie and her having a nice jacket and what that meant? Do you remember what that was about?
I would really like whoever is watching this on the computer at Law and Crime to move.
Said Sadie
their
dropped the
cursor
kids off at one night and
to get the bar off the bottom of the screen.
she was bubbly. Called him Zachariah. And said that she had a nice jacket in the back of
You'll
the
get
car.
arrested, Flux.
And suspected that she was going down to Kenosha to visit Junior because she had that nice jacket in her possession.
Really feels like that, Spike, honestly. Well, don't touch it then. True. Might not be a lucrative career, though. Oh, come on. Have you seriously not already laid out your entire plan on this? I mean, what the hell? Defendant's actually Anakin Skywalker. Yeah, I'm gonna be interested to see exactly what happens. Look, to be perfectly honest, Zenith, there hasn't been a huge amount. There were some definitely leading questions that the defense eventually objected to. And he's sort of just been going around in circles. Nothing really has been proven. Just, in my opinion, a lot of speculation. Potentially some hearsay.
No further questions of this witness.
Yes, thank you, Judge. Detective, I'm just going to start off with some follow-up on this interview that you had with Mr. Anderson, since that was just the last thing you talked about.
Sure.
You had testified just now that you had asked him about taking the registration from his truck, correct?
Yes.
And his exact response was, I don't have his registration card for his truck.
No, he said, spare me the accusations. That was the first thing he said. And then I didn't take it.
If I was to show you a transcript of that interview, would that help refresh your recollection?
Sure.
If I may approach the witness, Judge,
So do you have a copy for me?
I can show it to you.
I think they've probably got all the evidence that they're going to, Nissa. At this point, I don't think they've got enough to convict. 7:12. All right, I'll be back, guys. I gotta go get the little one ready for daycare. Be right back. Don't do anything to get me yeeted.
There were multiple points where you had asked him about the registration card for the truck, correct?
That's possible.
And he was adamant that he didn't have a registration card for the truck, correct?
He said he didn't take it.
And in your investigation, was there a state-issued registration card that was ever located in any photo at all for Mr. Gutierrez's truck?
I don't recall.
You had talked about earlier you had reviewed photos from Mr. Anderson's cell phone, correct?
Some. There was 4 cell phones.
So do you ever remember seeing a state of Wisconsin registration card issued to Mr. Gutierrez that was in any of those photos?
I don't recall there ever being a state of Wisconsin registration card involved in this.
Okay. So Mr. Anderson, when he told you that he did not have the registration card for Mr. Gutierrez's truck. You did not have any evidence to support that Mr. Anderson did in fact ever possess the registration card for Mr. Gutierrez's truck.
So I'm going to object as to irrelevant whether there's a Wisconsin registration. This is a Colorado vehicle. So the absence of a Wisconsin registration is irrelevant.
Well, it had Colorado plates. Is it a Colorado registered?
I'm not aware it's registered in Wisconsin or that
Well,
that's what
no,
we're
no,
talking
that's
about.
not what your objection is.
I'll rephrase the question to call a Colorado registration if that would, any state issued registration card
What's your question?
that you never found any information that Mr. Anderson was in possession of a state issued registration card for Mr. Gutierrez's truck.
I don't know. I don't know.
And let me ask you a question. You're a detective, obviously, right?
Yes.
You've been working, you said 20 years in the force?
Yes.
When you refer to a registration card, normally in your day-to-day business life as an officer, you're referring to a state-issued registration card, correct? As it relates to vehicles.
I guess.
Were you
Where am I referring to it?
Sure, I guess
Can
an
you-
example is, did you ever work patrol?
Yes,
When you pull someone over, right?
yes.
You'd say, hey, can I have your registration?
Okay.
Or when you ask for the registration, are you asking for a state issued registration card or something else?
Yes, state issued registration.
Okay, thank you. You also were asked about what information Mr. Anderson had given you about Junior or Mr. Gutierrez, and you said it was very limited, but isn't it true that Mr. Anderson admitted that he had looked up Mr. Gutierrez's information on CCAP?
Yes, he did tell me that.
And you were also asked a question about Mr. Anderson's statements about him being jealous and whether the state had asked you whether Mr. Anderson had expressed any concern about him about Miss Beecham dating Mr. Gutierrez. Do you remember that line of questioning?
Can you say that again, please?
Sure. Do you remember the state asking you about what information Mr. Anderson relayed to you as it relates to his feelings about Miss Sadie Beecham dating Rosalio Gutierrez?
Yes, he stated there was some jealousy.
He also stated, I'm seeing somebody else. She's got the right to see somebody else, correct?
He said that, yes.
You were also asked at length about what Mr. Anderson said he had done on May 17th, 2020. And isn't it true that Mr. Anderson in fact told you, I don't know, took a nap, probably. I think I went over to my girlfriend's house. I'm not really sure.
Yes, that's what he said.
And then later he did say, in response to other questions about what he'd been doing the last 2 days, he had informed you that he was tired and really didn't want to blur things together to give you wrong information, correct?
I don't recall him saying that. I know he did say he just didn't remember because his memory is bad.
And what time did this interview happen at?
11:30-ish till just after midnight, 11 o'clock to midnight.
So you agree that it's likely that someone could be tired after all day and then being interviewed at around midnight?
Sure. Could be tired. Oh, yeah, sure.
You also, in talking about Mr. Anderson's interview, talked about Stephen Lenz. Remember that?
Yes,
And that's Lenz.
correct.
May I use the Elmo judge?
Yes.
Thank you. And you said that, well, the state asked you that Mr. Lenz would be used as kind of a eyes for Mr. Anderson.
The state said that?
Well, yes. Do you remember being asked that questioning?
I remember the questioning about Mr. Lenz, yes.
And you said that there was communication between them that showed that Mr. Anderson was asking him to look in on Sadie's house, right?
Are you saying that I asked that?
No, I didn't say that.
Okay, because that long string of communication in your investigation doesn't exist, correct?
I didn't say that.
Okay. Did you see the communication between Mr. Anderson and Mr. Lenz?
No.
Okay. So you don't know what they actually talked about then?
I know there was text messages. I don't know exactly what those text messages said. I didn't deal with that part of things.
Okay. Do you remember who did?
I don't know.
I want to go back now to follow up on some things that you first started testifying about. Primarily, when you first got to the crime scene, you had noted that it's important to make sure that you're very careful with how you enter into a crime scene, correct?
That's correct.
And why is that?
We don't want to damage evidence. We want to preserve it as best we can.
And in your experience, you'd agree that when you are processing a crime scene or entering a crime scene, it's important to be extremely thorough.
Of course, yes.
Now, you talked about how Officer Van Wee, some other officers came in, and that they were very experienced in evidence processing as evidence techs, correct?
Yes, they are experienced.
You said they were specialists with Kenosha Police Department, right?
They have the title of evidence technicians.
Now, do you have any specialists that deal with missing persons cases?
Nobody with the title.
So you had noted during your direct examination that you were an investigator in this case, correct?
Detective, yes.
And role of a detective in a case with a missing person is to try to figure out what happened to them.
Yes.
And where they might be.
Yes.
And who may have been involved in the disappearance.
Yes.
So besides Mr. Anderson, who did you investigate as being involved in the disappearance?
Personally, I didn't investigate into anybody else. We did look. We looked for other leads, other clues, other evidence. But personally, I didn't take the initiative to go look specifically at somebody else.
I want to pull up an exhibit. And Judge, I apologize. I'm not going to use the Elmo at this point. The state's kind enough to pull up one of the exhibits since it's already connected. And I'm pulling up what's been previously marked as State's Exhibit 1, Photo 150.
Is the TV on though? We're working on it. Oh, okay.
Okay.
Counselor, you said 150.
150, yeah, thank you.
Looks like it's just getting.
I just want to make sure.
Thanks, Jessica.
Just quickly reading through chat to get an overview. I'm assuming I didn't miss much. Oh, they brought out the Elmo.
Yeah. Thank you. So you had previously testified about this photo, and you had talked about how there's a standby screen on the TV, correct?
Yes,
And it was determined that that was a standby screen for Hulu, correct?
I believe so. Yes,
Did you subpoena Hulu to get the usage records?
I didn't. No,
Could that have been something that you could have subpoenaed for?
Yes.
I don't know. I have never subpoenaed Hulu.
Okay.
Possibly.
All right. And then did you check the make and model of this type of TV?
No,
So you'd agree that there are certain TVs that have standby modes and sleep modes, correct?
I don't know.
If you left, do you have a TV at home, Officer Detective?
I do.
Your TV, if you turn it on, does it stay on or would it turn off after a certain point of time?
I don't know.
Okay, is it possible that you didn't check to see if this TV had a sleep timer or anything where it would have turned off after a certain amount of time?
I did not check personally. No.
And you agree that that could have been useful information in determining a firm timeline?
Potentially.
And then you had also talked about how there appeared to be some items that could have been knocked off, but you weren't sure. Remember that testimony?
Yes.
And you're not sure because prior to May 19th, 2020, you had never been into that residence, correct?
Correct.
So the items on the floor, it's possible they had already been on the floor because you didn't know how this apartment looked previously.
That's correct.
Thank you, State. I no longer need that exhibit up. Thank you. You also talked about when you looked in and you saw some pooling of blood that you noticed a void, right?
Yes.
And I think you said that that void was where a rug would have been at some point.
That's what it appeared like to me. It looked like a rug had been there at one point.
Did you determine the size of that rug?
I personally didn't.
Do you have any information of whether any officers in the investigation did?
Nicely phrased.
Not that I know of.
But you were familiar enough with the layout of and the size of the apartment, right?
Correct.
It was a relatively small apartment.
I would say that, yes. One bedroom.
Okay. It wasn't, in your opinion, it couldn't have been like an 8x12 rug.
No, it wasn't that big.
It was more like a 5'7" area.
From what I recall, that seems to be about accurate.
Okay.
Maybe a little smaller.
A little smaller than 5'7".
Yeah.
Okay. And you said that you looked in the bathroom. There was nothing of concern there.
Not that I saw.
You went to the bedroom. You said that there was nothing of concern there.
Not that I saw.
Judge, I would like the Elmo now. I appreciate it. Thank you.
Yes, that's very true. Okay, so apparently I missed a few fireworks. So I'll go back and watch that myself at some point. But just sounds from the sounds of it that it was as expected. She made him look like an idiot. So
Okay.
was that Jason J's a
Pulling
real give?
up
What did I miss?
what's been previously marked as Defendant's Exhibit 60. From
Yes,
you
memberships.
being there is
There they are. Just came up.
What room
Thank you
is
for the
this?
5 Aussie Overlaw'd memberships.
Appears to be the bedroom.
okay.
Like the northwest corner of the bedroom.
And the window, do you see the window in the picture?
Can you change the lighting maybe? It's hard to. Maybe we
Is
could
that
turn
better?
Yeah,
light
no,
up,
don't turn down the brightness.
As you wish.
Okay.
I get what he's
Light up,
complaining
right?
about. There's reflection on the paper.
I'm
but-
good. Can you see it?
Yeah, that's fine. Yeah.
Yeah, we're good. There's a window in the picture, obviously, right?
Yes.
That window, is it open or closed?
It looks like it's cracked
The
open.
blinds or the window?
The window itself.
Looks like it's one of the panes is cracked open.
Okay. And did you look into that at all? The fact that there was an open window in the apartment?
I didn't look. I guess what do you mean look into it?
Did you
So
follow it as a potential point of entry?
that window, I'll go back a little bit. That window is accessible from immediately right outside that apartment building, correct?
Yes, it looks outside to the north.
So an individual, if they wanted to gain access into Mr. Gutierrez's home, that could be a point of entry into that apartment, correct?
Correct.
We just saw that
Can't
the
last
window
maybe
was
20 minutes,
open,
huh?
correct?
I myself missed some of those.
So I don't know how many panes of glass are on that window or nothing like that. But it does appear as though the window is slightly opened.
Okay.
Yeah.
And that could have been a point of entry.
Could have been.
So you'd agree that that is something relevant in the bedroom,
Okay.
is
Yes.
it?
Sure. Yes.
And it's important when you
Really?
don't really know what happened to an investigating to determine every
Just saying,
possible
this-
outcome or situation of how an individual might have gotten into Mr. Gutierrez's apartment, correct?
Correct.
And you'd agree that that's one of them.
Correct.
You talked a little bit about your contact with an individual named Michael Campbell.
Yes.
Do you remember what he looked like?
I don't.
Okay. So you can't remember if he had any facial hair, what his hair looked like?
I believe he had a slight beard. But like I said, it was 2 years ago. I haven't talked to him since. I don't remember.
Okay. And the state had gone into what he was telling you, but he didn't tell you that he was at Mr. Gutierrez's apartment on May 17th, 2020, correct?
I didn't hear that. Yeah, I didn't hear him say that.
And when you were with Miss Beecham, questioning and talking to her, at any point did you observe her on her cell phone?
So witness order is determined by which party is presenting. So whether it's the plaintiff case or
I
the
may
defense
have.
case, and they choose
it's
their own
possible
order.
She used her cell phone.
Was she talking to anyone?
I don't recall.
Okay.
She is very confident.
Moving to your observations on Mr. Anderson's property, and you said you looked into the van, correct?
Correct.
I'm going to ask you some follow-up questions on that a little bit later.
Okay.
You looked in the dumpster. There was nothing of evidentiary value found there, correct?
Correct.
And you had noted something interesting that you located lath in the dumpster.
Yes.
And in your investigation, you were aware that Mr. Anderson was doing lath removal at a house in Belgium, Wisconsin, correct?
Yes.
And you said there were other areas on the property, and just in a whole, you did not find a body on the property, correct?
Correct.
No human remains on the property, correct?
Correct.
You talked about the flannel shirt, and if the state would be so kind to pull up that exhibit 40. Oh no, I think I got it, Jessica. Thank you. I'm gonna, for record purposes, pull up state exhibit 42. When was this picture taken?
I don't know.
This picture you know, wasn't taken on May 17th, correct?
Correct. I believe it was older than that.
It was much older, right? And you don't have a single photo of Mr. Anderson wearing that shirt on May 17th, 2020, correct?
I do not.
You don't have a single photo of Mr. Anderson wearing that shirt on May 18th, 2020, correct?
I do not.
You don't have a single photo of Mr. Anderson wearing that shirt on May 20th, 2020, correct?
I do
That's right,
not.
guys, for all your totes
And
and
you
sports
said,
bras,
the
head over to
state
the
had
merch
asked
store.
you about whether you searched the house and if you found the shirt. You said you had not, right?
We did not find the shirt.
Did you search Christine Remsburg, Mr. Anderson's girlfriend's house, to find that shirt?
I did not.
Did you search
she's
Miss
tearing him
Beecham's house to see if that shirt was there?
We did not.
So the only place you looked for that shirt was at Mr. Anderson's home.
There.
He does not want to answer that.
The house in Belgium. A tree farm, we looked.
Very funny.
Yeah, those three places.
Okay.
If
But
anything,
you
they might
didn't,
just be a
there
little
were
bit
places
white
that
'cause
you
they're so
could
buff.
have searched for it and did not, correct?
Potentially.
Okay. So I'm happy you brought up the house in
Oh, yeah,
Belgium. Were
Bruce
you
Bruce.
involved in searching that residence?
Me along with several others, yes.
And are you aware that the
Oh,
state
yeah.
believes that Mr. Anderson,
Hang on.
I guess, chopped up Mr. Gutierrez's body at that residence?
Objection calls for a conclusion that I don't think is an evidence in this case.
I can rephrase and ask a better foundation question.
But
You have no idea where Mr. Gutierrez's body is, correct?
Correct.
And you have no idea how his
If any
body
crimes are committed in the
or
in the
where
last
his body is
24 hours,
now.
we're pointing the finger
Correct.
at Dirk.
And
not contactable.
in fact, he's still technically considered a missing person, correct?
Objection, how would that determination by some mystery person be relevant in this case?
He's a detective in the case. Are you kidding me?
It's fine. I'll withdraw the question and continue on, Judge.
Oh,
In your
I've repressed
investigation,
that.
you were unable to determine what, if anything, Mr. Anderson had allegedly done with the body, correct?
Correct.
So when you went to the house in Belgium, you found absolutely nothing of evidentiary value, correct?
Objection, that would call for a conclusion by the detective.
Sure, I'll go into it differently, Judge. You found no human remains at the house in Belgium, Wisconsin, correct?
That's correct.
And you know that this, in your investigation, you're aware that Mr. Anderson had been there the morning of May 18th, 2020, correct?
I know that at some point he was determined to be there. As far as the exact date and time, I don't know.
Okay. And you found
Excuse me. He's
no
getting
blood
squirrely.
evidence or suspected blood evidence, correct?
At that house?
Yeah.
No.
Did you find any trash bags filled with body parts?
No.
Okay.
That's one way to put it.
Did you find any bloody knives?
No.
All right. Did you notice that the property was under construction?
Yes.
And did you see that there, I don't know your expertise in the line of contracting work, but you had testified you had seen lath at Mr. Anderson's home. Did you see things consistent with lath removal at that property in Belgium, Wisconsin?
It's likely that's where the laugh came from.
Okay.
No, in this case, the prosecution's
You
getting.
know, I want to move back to
It's
Mr.
in
Anderson's
sandbags.
property.
Right.
You said that you had looked into the black van, correct?
I did.
And you noticed that the van carpeting had been cut out,
Yes, is missing. Yes.
missing. But you cannot definitively say your investigation didn't produce any definitive answers as to when exactly that carpet was cut out of that van, correct?
Well, objection. His investigation does have witnesses that put a time on that.
Well, then he can answer the question. I think it's a totally plausible question.
Mm-hmm.
Why would he be charged with that knowledge?
I'm asking him if he knows.
Well, he can answer if he knows.
Correct.
Yes, I know. I know. We have it narrowed down to when it was removed.
And that was solely based on statements of another witness, correct?
Correct.
It's not based on photos of
Actual
Mr.
evidence.
Anderson removing the carpet, correct?
Correct.
And there were no other witnesses that could corroborate that one witness's statement, correct?
Correct.
That was one person's
You
word.
talked about some duct tape and rope. That was also from a single witness, correct?
Correct.
You were not provided any photos of that duct tape and rope, correct?
That's correct.
And you had never observed
I don't know
that
if
duct tape
he's
and rope prior.
Competent at his
at
job.
Mr.
I just think he
Anderson's
didn't do a
home.
great job
No,
this
I
time
don't.
around. Yeah, he knows he's taking this case.
The state, kind of going back to the cross-examination or the direct examination on Mr. Anderson's interview with you, had talked about and asked about Mr. Anderson not really admitting to which car he drove, but he said he drove the Audi and the van, correct?
City primarily drives the Audi. He doesn't really use the van.
Did he say he used the van for work purposes?
Yes.
And your understanding is Mr. Anderson's work is as a contractor?
Well, can I approach?
If there's
can
an
I-
objection, they can state
Well,
it.
I think the question opens a door to this officer. He has some knowledge that question. I guess I have no objection. The question was asked, what is his current job, or what's his
That
source of
wasn't
income?
the job.
That's
That
not
is
exactly, but
that question's been asked. Let's let it be answered. I don't object.
all right, everybody's on
Okay.
board, so.
You go ahead and answer.
Well, if we can have one moment.
Mr. Prosecution, shut the fuck up. Oh yeah, she's got total control of this courtroom. No, he objected from what it seems like that was a reactionary objection. He objected because he thought that was the appropriate thing to do. And I'm curious as to why now he's going on about who gives a shit what the detective's current job is.
I'm going to re-ask the question.
There was no objection. Can't he answer the question?
Do you remember the wording of the exact question, officer?
Yeah. What he did for work?
Were you aware that Mr. Anderson was doing contract work at that time?
Yes.
And there was evidence that Mr. Anderson admitted to that proves that he was driving the Audi around this time, primarily that he was driving the Audi on April 24th, 2022, correct?
And doing a terrible job of it.
I don't know if he specifically told me that. He did say he was operating a car that night.
And that was confirmed by other witnesses.
Correct.
His current job is staging crime scenes. Yeah, not disagreeing with you on that, Mithril King, but remember, we've already had 2 trials, including a mistrial. This one got dangerously close to having a mistrial as well. I'd at least be taking a crack at it, honestly, particularly with the level of evidence that's being provided. I want to say no, but fuck it, I remember. Cop looks so uncomfortable. Yeah. Yes, he does. because she's asking questions that he does not want to answer, and whoever said it is right. Look, again, I don't know that he is necessarily an incompetent detective usually, but it's very friggin' clear that people had blinkers and tunnel vision on this case. It's all for charity. Ooh, I've got things in the way of the video. Hang on. Oh, we did not win that exchange.
Okay, I'm putting what's been marked as Defense Exhibit 59 up on the screen. Do you recognize this?
Yes,
Okay, and that was a pizza box and receipt that was on the stove at Mr. Gutierrez's apartment, correct?
yes.
Did you
Tell me
investigate
there's a receipt
this
on
at
that.
all to see when this delivery was dropped off?
I did not.
Do you think that would have been
fuck's sake.
useful if maybe if it was dropped
Establishing a
off, let's
timeline?
say, on the 17th at night to talk to the delivery driver?
Potentially.
Because that delivery.
If it was, I don't know when it was dropped. I didn't look at the receipt.
But there's potential.
course not, 'cause that'd be part of your job.
investigatory, Points that could have been covered in investigating this,
Potentially, yes.
and it wasn't, correct?
Objection.
No.
Are you indicating that nobody did this or he did not personally do this? Objection as to vagueness, I don't understand the question.
You can cover it on cross or redirect
And I'll even cover it.
if the
right-
witness understands the question.
I didn't investigate it.
Okay, and I'll just ask the question the state wants to ask, which is, are you aware of any other officers investigating this?
Huh?
Okay, so I'm going to object because it implies that he would know if other officers did. No one has indicated that he would have some overall
He
supervision.
may have that knowledge, though.
Judge.
What's wrong with the question?
Previously testified that he was one of the lead detectives in this case.
Well,
I don't believe he had.
I never said that.
he testified that when he arrived, there was one other detective who was there, but I don't recall any testimony that he is saying that he was the lead detective, but I don't know if he did or not.
Were you aware of other tasks other detectives and officers completed in this case?
Some,
Okay, and the some that you do know if anyone investigated this?
I don't know.
Okay, thank you. Showing what's been marked as Defendant's Exhibit 61. You're familiar with the fact that, well, let me strike that, rephrase. Did you look at the dumpsters in Mr. Gutierrez's or near Mr. Gutierrez's apartment?
No,
Are you aware that that happened?
I don't know.
Okay.
Another one for the defense.
You were at Mr. Anderson's home, correct?
Correct.
You looked around the property, you said before, right?
Correct.
It says marked as Defendant's Exhibit 76. Did you notice the trash bags up against the barn at Mr. Anderson's home? I'll zoom in for you if you need.
I don't recall.
Okay, but you'd agree those are trash bags in this photo, right?
That's what they appear to be, that, yes.
Okay, great.
Mm-hmm.
Then you said when you were at Mr. Anderson's home, you had looked into the van, correct?
Through
Did
the
you look
window.
at the front window too?
I believe I made my way all the way around the van.
Okay, so I'm going to show you it's been marked as Defense Exhibit 62. Is this an accurate depiction of the front seat of Mr. Anderson's van?
What are we looking
Appears
at
as
there?
such.
Okay, and there were tools in his van, correct?
I believe
Clearly.
so.
You'd agree that those are tools or a toolbox of some sort
I was
on
the first
front
attending
passenger
detective.
seat.
Okay.
Yeah, tape measure, tools, looks like a tool bag.
Okay. And you'd agree that there's a lot of cluttery stuff around there too, right?
Yes.
Okay. I'm going to show you what's been marked as Defense Exhibit 65. This is another view from the behind of the vehicle, correct?
Correct.
And you'd agree with me that there's a lot of dirt and stuff on the floor, correct?
Looks dirty.
Looks dirty. It hadn't been vacuumed or meticulously cleaned, correct?
Ex-coma.
Doesn't appear as though.
Okay.
Yeah, I have no idea
I'm
what
going
that
to
was
show you
about.
another picture of the front, defense exhibit number 66. Again, lots of items, correct?
Yes, very busy.
And this is how it appeared to you on, was it the 20th of May?
Yes.
Okay. And another angle of the front seat taken from the passenger, defense exhibit number 67. Again, lots of items, correct?
Yes.
And this is how it appeared to you.
From what I recall.
Okay,
The
great.
first time around, the prosecution kept some information from the
Showing you
defense,
more pictures of clutter here.
and it didn't allow them
Defense
to
exhibit
interview
68.
a certain
This is
potential
the
witness
front of the
properly.
vehicle, correct?
Yeah, between the two front seats, looks like.
And we still see a lot of that clutter,
Yes.
and that's how it appeared to you.
From what I recall.
I'll show you another picture from inside
He's
the
like,
van.
damn, I should have cleaned the
Defense
car better.
exhibit 69. I think you can see that dirt and trash a lot more clearly, correct?
Yes.
Does this look like a car that has been cleaned to you?
Doesn't appear so.
Cool.
You said you also went to the tree farm to help with the search that was executed there.
Yep.
And you're aware that there was a burn pit at the tree farm,
Yes.
and multiple agencies had come to process that burn pit, right?
Yeah, there was
Especially given that the
part-
carpet's being removed from the back third of that
took
van.
part.
And you were able
That's where
to
it was taken
confirm
from. I'm
that
calling
there
Russ.
was a controlled burn there on May 8th, 2020, correct?
I believe that was the date. Yep.
And that the owners of the tree farm had alerted the Ozaki County Fire Department of that burn.
I believe so, yes.
Okay. So I'm just going to show you some pictures. This is defense exhibit number 70. This is part of that linear search of that burn pit, correct?
Yeah, so I didn't take part in most of that
Okay.
search. I was doing other things.
Okay, but
That looks like the burn pit, and that looks like what they were doing.
Sure.
Searching.
so maybe I'll just ask you then, you were aware that that was a large operation,
Very large, yes.
and they didn't find any human remains there, correct?
Not that I know
And they didn't find any bloody evidence there, correct?
of. Not that I know
Did they find any human remains there?
Back to Mr. Gutierrez's home, I'm going to show you what's been marked as Defense Exhibit 58. The number of his apartment building, 3709, that you can see that in this exhibit, correct?
Yeah.
And that 3709, you can see that from in the parking spaces right in front, correct?
Yes.
And you had been at this scene during the day and at night, right?
No, I was there during the day.
Not at night? Okay.
He had better things to be doing at night.
As part of your investigation, you talked to an individual named Kim Lavora.
I did. Kim Labora.
Guys, I just want to say thank you to everyone that subscribed. I'm well on my way to 10K now. Already at 9,118.
Yeah, you need to
Okay.
clarify that one.
Yeah.
We talked to a ton of people. So.
Yeah, counsel, I'll stipulate to the record if you just want to do that, you're not going to ask what he asked or anything.
Correct.
So I'll stipulate rather than, if you want to refresh, you can, but if you just want to,
I do want to refresh.
Okay.
Thank you.
She's going to do the opposite of whatever he wants her to do. Because at this point, he's already shown that he's a little bit slimy. There's no way I'm getting to 50K before Jeff does. He doesn't work past 5. Oh yeah, he thinks he's got complete control of the situation, and he is fucking over quite well. Don't worry, D-Wade. That's at 15K, and that's not on YouTube. That's on a. I'm going to set up its own site for one single 24-hour period. Hit the like button, or Hayden will eat a koala. I think it's illegal, actually. pull the snot. I could have done without that. Thank you though. Oh no, I couldn't care less about the caps lock. Didn't need the picture of the pull of snot though. Ugh.
Okay.
What movie, Stingy?
Oh, okay.
Counsel, for purposes of the record, you don't want him to read it out loud. You're just
No,
refreshing his memory.
For purposes of the record, I've handed the detective a copy of his own report to refresh his recollection. Does that help?
Yes.
Oh, I didn't mind Gable.
Phone records were
I feel like he's setting me up.
obtained in this case from Mr. Gutierrez, correct?
Yes.
And I'm going to show you what's been marked as Defense Exhibit 75.
I'm a little worried he's in the room giving tips, honestly.
Probably going to have to zoom in here and focus, so bear with me.
Well, given the hour,
This is going to, go ahead, Judge.
well, if it's going to be brief.
With this point, yes. Then I have some other stuff. But
Well,
I'm-
I know that. I wasn't going to put it in your entire examination. But it's 1 minute to 3 blocks.
This will be like 1-2 questions max.
All right, I'll get there.
Okay. I won't disappoint.
I'll bet you won't.
So this phone record shows that these are Mr. Gutierrez's phone records show that he called a Kim Facebook on 5/17/2020 at 8:49 p.m., correct?
Appears as though yes.
And that when we look further up, there's a duration column, and the duration of that
Technically, this is
phone
my acting
call
career.
was 17 minutes, 4 seconds, correct?
Appears as though, yeah.
I lied. I have 3 questions, Judge. So if
You did
there's a phone
disappoint.
call that started at 8:49 that lasted 17 minutes, that's going to put that phone call to approximately 9:06 p.m. I'm terrible at math.
Yes.
Okay. Thank you. Judge, if you wanted to take a break.
Well, I'm only doing it for others.
How long is he taking for?
Let's take a break, and please don't read what your list running on account of the trial. Discuss the case with anyone, and let's
Not
aim
what I meant.
for about a 15-minute break. Any
15-minute break?
questions?
Okay.
Okay, thank you.
Let's see where they are with the Triple X trial, shall we? Oh, excuse me. Oh, of course, they're on a black screen, so probably a sidebar. Oh, look, they have their own. Oh no, this video. Sorry, I thought that was going to be a what do you call it? Like a PowerPoint. Anyway. Say thank you for tuning in. They done for the day? I think they're done for the day. Maybe not. I don't know. I really don't fucking know. Where are we? Judges liking her in a professional setting? Yeah. I was disappointed. That sucks. That is evil, letting him sweat in the break. Oh, yeah. Yep. So Kenosha's had 2 trials now that never should have happened. Yep. Basically, if this is the amount of evidence they had for the first trial as well, absolutely no way in hell that should have happened. There's a porn trial. Oh, no. Sorry. Hang on. Where are we? Hang on. I just had that. Where did it go? No, the Triple X Tentacion, the rapper that was shot. Basically, for anyone that wasn't is unaware, before I started covering this trial, I was covering the Triple X Tentacion trial. He took 50 grand to a bike shop, thought it would be a good idea, went with his uncle. 4 guys followed him in. They realized who he was, so they came out, pulled out of the car park, pulled in across the street, waited for him to leave the car park, basically cut him off. 2 guys jumped out. They stole the bag, I think it was Louis Vuitton bag containing the 50K, and shot him with a 22, and he died. To top it off, a fan walked up and took a selfie with his dead body, and his uncle, who was supposed to be there for his protection, legged it. Like, he literally got out of the car and ran as fast as he could. So I was covering that. This one's slightly more interesting. The audio in the Triple X trial is horrible, but I am going to go back and rewatch it and do reviews once this is all over as well, just to keep things going. But yeah, so no, not a porn trial. Member needs to stop smiling. Let's just try and be respectful, people. We do have potential family members in the chat. But yes, I agree. Hairstyle could be better for court. Just saying. My own personal opinion. Defendant looks really sleazy. I don't think he's smart enough to disappear someone. Extremely difficult to pull off. Well, there you go. Kenosha seems to bring a lot of cases that shouldn't have happened. This is true. Oh yeah, that's right. The bag itself was worth 50K, and they never stole the bloody car, which was worth more than that as well. This case is more entertaining, in my opinion, though it's also pissing me off more. Fair enough. Oh, she doesn't care and rips on him too. Oh, you got permission? Okay, well, have at it then. Speaking of the porn trial, isn't Should Business next month? Should Business had a competency hearing. You'll have to double check with Jeff whether or not that went through. Actually, you know what I will do? I'm going to check because there's 2 trials. So Should Business, let me check the timeline on that. Oh yeah, no. And by the way, if you do commit a crime and you steal a whole bunch of money, don't immediately the same day and the day after go on Facebook and fan it out and wave it around, to flex and show off how you're balling, just because you've got 15 grand now. Because by the time they split it all up, I forgot the best part about that trial too. The 4th guy, so 3 of them are on trial. The 4th guy pled guilty to 2nd-degree murder and flipped on all of them. He gave evidence in the trial against the other 3, which I thought was fucking hilarious, because the other 2 of the other 3 didn't want to give him any money at all, and one of them suggested that they give him 5 grand. They tried to fuck him over, so he fucked them over because he knew that they were going down. It was very funny. As a detective, do you have any proof that the alleged victim is even dead? Zach is 42. There you go. Hey, Nando's member. Yeah, I'm pretty sure it's Matty. Oh, see, thank you for reminding me. This is why I've got to get chat tested for ADHD, honestly. I swear to God. So that's from the 14th. Do we have anything more recent? Is there anything from like the last week? Attorney of suspect in Green Bay dismemberment murder trial removed from the case. No shit. Just breaking. Should Business's new attorney has asked for a different judge. Should Business 25 is charged with 1st-degree intentional homicide, mutilating a corpse, and 3rd-degree sexual assault for allegedly attacking Chad Therian last year. For anyone that is unaware of this case, and I'd be shocked if any of you weren't, this is the chick that cut off his head and Johnson, pleasured herself with the Johnson, allegedly, and left his head and other bits and pieces in a bucket that his mother found. After she attacked her, where did it go? She's pled not guilty and not guilty by reason of mental defect or disease. After she attacked her attorney, Quinn Jolly, on the 14th of February at the hearing, Jolly left the case. A hearing was scheduled for Friday with the new lawyer, Christopher Froelich. In his first act on the case, he asked Justice Thomas Walsh to remove himself from the case because of the attack. That's fair. I can see how that like he may be biased because of it. I can understand how he may have made the application for recusal on that. Um, the issue of the defendant's competency is still being evaluated by a licensed psychologist. The apparent incident did occur in the courtroom before the assigned judge, who had the opportunity to observe what happened, citing state law that the appearance a judge cannot act in an impartial manner is a reason for the judge to recuse himself from the case, and asked for that. The defense has a concern about potential prejudgment of the defendant due to the apparent incident in the courtroom, the motion states. The defense counsel asks that the court graciously consider these issues raised under state law. The defense counsel does have concerns about the defendant's mental health status, and any motions can be considered once the defendant is deemed competent to stand trial. Competency refers to the defendant's ability to understand the court proceedings and assist in their own defense. It does not relate to a mental condition at the time of the attack. The issue of competency still has not been decided, which is one of the reasons the March 6 trial was postponed. She's expected in court Friday afternoon. Okay, so we won't know for another couple of days. Oh god, that was funny. That was funny. Thank you for reminding me that, Eliza. You were so fearful of your life because it was Drake, allegedly. You don't want me to answer that. No, I think I really do. No, it's because they were gang members. Whole court just goes, fuck it. Chad and Laurie Daybell are being tried separately now. Are they? Interesting. Wait. Family of the defendant is in chat. Hello. If he smokes, vapes, menthol, vote not guilty on principle. There you go. Anyone watch Redacted on YouTube yet, guys? No, not at this point. Is that something we should do? Must be so happy with this. If we can see the idiocy, the jury sure as day turns to night can. Fingers crossed. I mean, if there's a whole bunch of morons. But yes, very much fingers crossed. I'm just going to put that back just in case they come back while I'm doing other things. Same DA as forced the Rittenhouse trial. They're just trying to delay the inevitable. At this point, feels like it. Unsung hero, if he has a man bun, he's probably shot the gun. Someone's trying to come up with a clever rhyme there. What is your business? Yep. I remember that courthouse wood relief carving from the Rittenhouse trial. Apparently, the founders of Wisconsin suffered from scoliosis. Really? Interesting. 2 heads in 1 bucket. Wants to quit that case so bad, and he wants a new judge so he can quit. Quite possibly. I mean, if I was him, I'd be sitting at least 2 seats away from it, that's for sure. Did you miss anything? Just the defense counsel tearing the detective to shreds. It's a very effective cross-examination. I'm not going to lie. She was impressive. If that was just on that, the prosecution will have to do a fuck ton of rehabilitation that I don't think they've got the opportunity to do. And I think that, oh, hang on, I can make myself bigger here. Do we like that or not? Anyway, the prosecution will need to do a fuck ton of rehabilitation on this witness. If this was the sole witness, I'd be resting the defense's case right now, honestly. Let's see. No interesting legal story in the Triple X case whatsoever. Here, there's no body. That's interesting. Edgecombe, it was whether they would believe self-defense interesting. True. She wants a new judge because he didn't look impressed with the attack. Should business just had prison time on her bucket list? I'm sure she did. Flux, thank you for the $5 super chat. I'm never moving to Wisconsin. First with Stephen Avery, then Kyle, now Anderson. Shit, someone needs to do something about the state prosecutors there. I kind of feel like the prosecutor's office needs to be gutted. I don't mean I mean metaphorically, not physically. I mean that they need to clear them all out, and they need to basically rehire everybody from the ground up. So, but thank you for the super chat. Also, there was one here that you also left. When I retire, I want to stand outside the courthouse with signs saying, "Screw the government, look up jury nullification." We can always hope that people would actually do that because although it's not specific, although it's not technically allowed, if it's very clear that people are getting railroaded, then it is something that I believe that the public should be aware of that exists. Not that I would in any way ever, Your Honor, any chance that you're ever watching this, anyone from the Legal Ethics Committee or anything like that, I would never condone that. I just think it's appropriate to have the knowledge. Freaking love this defense attorney. Yes, I wholeheartedly agree. She's good at what she's doing. Just double check through here. Isn't the Sarah Boone case set for April? Could well be. Could well be. That's not one that I was planning on. I mean, at some point, guys, I have to go back to my usual content. And at some point, I need to get some sleep. That's why I'm liking this trial. I don't actually have to get up until like 4 a.m., which is great. The cleavage is impressive. Fair enough. When's the next Darrell Brooks hearing in Minnesota? I'd have to look it up. I saw a video of his last one somewhere, actually. It's really funny when they take him into the courtroom with the whole, like, what do you call it? Like the face mask and all that sort of thing. Brooks is Wisconsin as well. Objection unbased. Thank you, Spooky Spoon. What do we think of the beard? Like, it's coming in eventually. I've actually got to shave the rest of it at some point, but it's getting there. Been watching Brooks CCAP. Still has an open case in Milwaukee set for conference on the 23rd. Okay, well there you go. If they're retired, though, we just get other woke lawyers, overly woke lawyers. I may never say this again, but a competent woke lawyer may be better than an incompetent based lawyer. You may never hear those words ever come out of my mouth ever again. Why are they shaking the camera? Camera is bouncing. Cameraman's getting a BJ, apparently. Wisconsin is weird, very purple state that rarely removes incumbents. Okay. I believe this detective was a lead guy on this. They brought him on because he is lousy, not confident. This is true. Most American DAs are elected. Okay. Sleepers for the week? Yes. But even the mighty boulder will be worn away by the tide over time. Young people nowadays aren't as modest as we were. Yeah, the spit mask. Yep. Based beard. Thank you. Going for the soul patch? I haven't decided yet. I mean, there's two little bits here. Like, you can't see it because, unfortunately, thanks to stress and age and all that sort of shit, some of the beard is coming in salt and pepper. I'm not going to lie. There's whites through here. These two bits here, though, on the side, for some really weird reason, are completely blonde. You can't really see it. There's fur there that's about as long as the rest of the beard. So, but anyway. Full beard over goatee would look better with your chin and jawline, but that's just me. Fair enough, I appreciate that. The only thing is it really, like, because I get, like, ingrown hairs a lot on the jawline, so it causes problems and chafes and shit. Goatee makes you look a bit younger. Really? I thought the baby face made me look younger. Okay. Has pros and cons in the industry you're in. Only takers do what you want. Fair enough. Cheers. Never thought of saying competent and woke in the same sentence. Yeah, like I said, I never thought I'd say those words ever again. I'm hoping I never do. No, that was some fucking bullshit. Okay? That was some absolute bullshit. The Baldo will never die. Nope. The best ever. Cheers. That's your age, not stress. I'm 32. Gross. What does Lady Overlord think about it? She's not happy about it. Let's put it that way. Have I lost weight? Fuck no. Nope. Putting weight on, which I'm trying desperately not to. Grey hair could be a vitamin deficiency. Could well be. Could be too. Hang on. Let me see if I can bring up that. There's got to be somewhere on Twitter where I had that. Oh look, someone did a Oh, I don't want to do the color flashing. See if I can find the. For anyone that isn't aware, footage was released across TikTok and various other platforms of a cross-dressing drag, basically strip show, effectively, in front of like toddlers and young kids, and they were handing out tips to the entertainers. And I use that word loosely because it was, look, good on them for trying, but it's not something I'd pay to see. Even if they were like straight women doing it, I wouldn't pay to see that. Wouldn't trust a beard in Oz. It's just another place for spiders. Oh, I don't tell my wife that. She'll shave me in my sleep. Keeps getting thicker as you get older, but it takes longer to grow in. Okay. Also, in my early 30s, stress has plenty of salt in my beard and shaved head of hair. Just what it is. Mad jelly you can use. Homemade, though. Oh, Tim Pool covered it. Okay. That would probably give me a reason. Where's the footage? I know I had it. Wait, what? Judge Newman in the Alex Murdaugh trial has removed a juror for misconduct. Is this maybe because this juror was potentially going to vote to say not guilty? Wouldn't fucking surprise me. I can't find a copy of this video that doesn't have the flashing lights on it because everyone's showing that version of it as of today, whereas the version that I had yesterday was. Is there like a history so you can look at previous tweets that you've looked at? I hate Twitter at times. I really do. Oh, wait, what am I doing? I tweeted it out and said, what the fuck is this shit? Hang on. Moron. Wait, did I? Or did it get taken down? Wow, maybe it got taken down. Oh, no, there it is. Okay, hang on. Should bring up. I want a private tab. I don't need to be sharing my details. Take that out of there. I'll move that across there. Put that as full screen and share this tab instead. Turn off the audio. But yeah, check this shit out, people, if you haven't already seen it. You son of a bitch. Why is it little? Taking forever to load. Oh, have I got something open that's pulling out my hang on, I'm just gonna close a few things. I think maybe I'm pulling off too many close that, close that, close that, close that. Leave that one open. I think we're churning through the. There it goes. So this was in front of a whole bunch of kids. Son of a bitch. And court's back. Does it count as court's back if it's just him on his phone? Yes. Remember to switch over to live chat from top chat, people. Yeah.
Would you come
And see,
down
the
there?
annoying thing is, I
Thank you.
blame the parents as much as I blame the artists, because someone pointed out yesterday, the judge is checking Twitter, someone pointed out yesterday, it would be simple enough, like, if you thought this was an adult event, and you were the entertainer, if you walked out of that room and saw all those kids, it'd be simple enough to go, no, not doing this.
On the stand.
Okay?
Yeah, going back up. Yeah, sorry.
Yeah, look, they can do whatever, provided that they're over the age of 18 and their partner's over the age of 18, they can fucking do whatever they like. Just don't shake it in my face, and not in the presence of children like that. It's not appropriate. No, there's a separate video sovereign where there are definitely dads there. Because I don't think this is the video. I don't think I played the whole video or the one that I watched. But one of the dads like holds out money for the entertainer, and gives the kid money to hand over to the entertainer as well. He's watching us. Hey, Judge. Love your work. He's playing Panda Pop.
Okay.
Yep, I can agree with that. Yes, we're all very big fans, Judge.
Yeah.
I just want to say a quick thank you to everyone that has subscribed today. 'Cause that
Next
number's already
one.
going up as well. So thank you very much.
All right, I'm pulling up what's marked as Defendant's Exhibit 63. This is
The couch. Looks like to me.
a picture of the dash in
Oh, I stand corrected.
Mr. Anderson's van, correct?
I'm going to object, Judge. The detective has indicated he took a brief glance in without entering the van. I don't believe he's a witness who would be able to talk about details of the of areas of the van that are not the cut area in the back or the bleached area that he's testified to. So this is a close-up view. He says he took a brief glance. I don't think he's a qualified witness to testify to this exhibit.
Then he's qualified to be on the stand to say that he only
can
took a
respond
brief
if
glance,
he
which was
doesn't know
not
the
part of
answer.
his. He's qualified to say he didn't do his job.
Okay, that's fine. That was 63.
Apparently, to not give evidence as to something that was in the front of the vehicle. But he can give plenty as to the back of the
Reflection
vehicle.
or fresh, just let me know.
Okay.
Do you remember on May 25th, 2020, reviewing video footage from a High Line gas station?
Yes.
And that gas station was located near Mr. Anderson's home, correct?
I believe it was at the interstate near the tree farm.
Okay. And so if it It was in Ozaukee County or Sheboygan County then?
Ozaki?
Okay,
I'm guessing. I'm sorry.
it's fine. I could give you the locations you put.
'Cause it's
in your
devastating to
report.
my
I don't know if
case!
That would help. You said
Please.
located at Interstate 43 and County Road D.
Correct.
Okay.
Yep.
So Ozaukee County?
Yes.
And the reason that that gas station was important was because if Mr. Anderson had traveled to the tree farm or back from his home, he would have passed that gas station, correct?
Objection. We don't, the detective would have no ability to know the route that somebody took to get to someone's home. Presumably, there's a number of highways, number of roadways.
Does GPS
I'll
tracking
rephrase
data
it.
that should have
Why
been
was
pulled
getting
not
and
prove
reviewing the
that?
surveillance video of that location important to law enforcement in this investigation?
It was a potential route of travel.
And you reviewed several hours of video, correct? For the Highline gas station.
Yes.
And you reported that you did not see Mr. Anderson's black minivan, correct?
So the cameras were
Answer the damn
substantial
question.
distance
It's a
from
yes
the
or no.
road. And at nighttime, it was almost impossible to tell what cars were going by. So I don't know what cars were going by. No, I didn't see a black van drive by.
And in your report, you were clear that you reviewed several hours of video and did not see the black minivan.
Correct.
You also indicated that on May 26, 2020, you continued to review video surveillance, correct?
Of what? What surveillance are we talking?
Yeah, I was hoping you could answer that. Can I show you your report?
Sure.
Oh no, I don't want them to throw out all of his testimony because his testimony has been damning for the prosecution. If they throw him out completely,
So
Did that refresh your recollection?
yeah, so we had hours and hours and hours of video from multiple locations we took. I didn't document what I looked at there, but we reviewed several locations. I don't know specifically what I was talking about when I mentioned that. in my
is not
report.
fucking around. This ought to be good.
But is it a fair guess that those were locations of interest due to potential traffic patterns of Mr. Anderson?
Potential routes, yes.
And in your report, you noted that you observed nothing of evidentiary value, right?
Correct.
And can you explain to the jury what nothing of evidentiary value means?
I saw nothing regarding the black van,
I saw
black
nothing.
Audi,
Oh, nothing.
or anything related to Mr. Anderson.
I have no further questions subject to redirect.
I'm going to start from the back. So you were just asked about some video that it sounded like it was a gas station location that you looked at.
Yes,
Yeah, you're not
and that
kidding,
appeared to be on
she's
May
not fucking around.
25th, 2020, correct?
correct.
You wrote a report that memorialized those fascinating hours, I assume, right?
Yes,
Counsel read to you, I reviewed several hours of the video and did not see the black minivan. Do you recall that just being read to you?
yes,
Is the next sentence in your report, however, the video was from a great distance, making it difficult to make out traffic, especially during the hours of darkness. Is that what you say next in your report?
Wait. Is he fucking kidding me? I'm going to pause it right here. Is he fucking kidding me? The video was far enough away and it was dark that you're not going to see a moving vehicle. Fuck
that's what
right
I
off.
testified to as well.
And so when counsel read to you the first sentence, you had already also tried to testify as to the second sentence, and it's also in your report. Is that right?
If you just read it, it's in their report.
You have no reason to dispute it. Would you like to take a look?
Sure.
I'm going to object. This witness has already testified to that contents, and the video was poor quality and it was dark.
Well, Sorry, it's the next.
Yeah. What page? Wait, actually, Mike, what page is that?
It is.
Ooh, they're on a first name basis. Hey, Mike, what page is that?
So I'm just going to ask you to take a look at your report and ask you, do you agree that after the first sentence that was read, there is a second sentence and it's what you tested?
Oh, I don't reckon I can
Yes.
show that one.
So it's also in your report, is that right?
Yes.
We may do a Rumble exclusive at some stage to bolster the channel over there, but I don't know that I can show that one on YouTube.
You were shown on the doc cam just a minute ago, or I'm sorry, before the break, the signage indicating what the 3709 address for apartment 1B. Do you recall that?
Yes.
And that picture was one where you said that the sign was visible, correct? Like would be visible from the road.
Yes.
Do you recall
From
testifying?
15th Street. Right? From the road.
That's it. Yep. So I'm going to show that to you on the doc cam again. Does that appear, as best you can see, to be? Of course, I forgot that you got to do that. Does it appear to be a daytime photo, if you can tell?
It is.
Okay. At nighttime, would you expect there to be substantially different visibility?
I'm going to object. I asked this witness if he had been there at night, and he had said he had not. So it'd be purely speculative.
Well, I think he could.
Nicely done.
Go ahead.
At night, would you expect that signage to be significantly more difficult to read?
I would believe that to be a safe assumption.
Okay.
It's dark.
And on the
Objection,
17th
Spectre.
of May, do you believe
You
it to
literally
be
said
heavy?
what
Was it
assumption?
heavily raining?
Yes.
Was it heavily raining at night?
Yes.
Have you, and so if I add in heavily raining at night, would you expect the signage 3709 to be different and more difficult to read than it is in the current state of the daytime photograph?
Rain can
What else has
obstruct.
it been on
Rain
locals?
would obstruct.
I should do something over there.
the sign.
Can you show videos? I still had issues with that.
You were shown a picture. It is Defense Exhibit 65, where you were asked if whether the van, and this is the defendant's van as best you know, correct?
Correct.
You were asked if it appeared to have been meticulously cleaned. You recall that?
Yes, that's what I was asked.
Okay. Now, this is not the same view you saw. You saw the van during the day, for instance, correct?
Through a window, yes.
When you saw it, did it appear to have been selectively cleaned as opposed to comprehensively cleaned?
Yes.
Okay. And what left you to the conclusion that instead of someone comprehensively cleaning the van, and have you ever cleaned one of your cars?
Yes.
Do you normally, detective, clean only small portions of your car? Say, if you have a minivan, do you only clean the back third?
Typically not. No.
Would you use bleach on just certain locations, or do you typically clean the entire automobile if you are engaged in your normal activity?
Clean the whole
Question,
automobile and then wouldn't
objecting.
use bleach on carpet.
Okay. So when you observed what appeared to be bleach stains and the back cut out, was it your sort of at least beginning conclusion that someone had made some efforts to do something to that minivan that wasn't involved in just trying to keep it clean?
Yes, it definitely wasn't normal.
Yes, it was Tweety. It was
I'm
either
gonna
that
show
or
you what's
boobs.
been marked as
I needed
case
something to
exhibit
distract me.
59. Do you recall this pizza box from your walkthrough of the scene?
I know there was a pizza box, but my walkthrough was what it is, a walkthrough. I didn't stop and
Don't you
do
fucking-
crazy examinations. I didn't
That's the purpose of a fucking walkthrough.
evaluate evidence.
You still
while I
acquaint yourself with it
walked through the
yourself.
residence to get a gist of what happened.
So I guess I'm
The
going to ask
Discord
you,
should
Frank,
be in the link
are you
at
the
the top
best
of the chat,
person
in the
from
link
the Kenosha
tree.
Police Department to testify as to each of these areas or items and whether anyone collectively on this investigation did anything further? Are you the ideal person to ask those questions to?
No,
For instance, if a
Why you want
officer
to stand?
called the pizza place and made some determination that this was not an issue in this case,
Oh,
in other
thank you
words,
very
in
much,
terms of the
AP.
timing, would you know that one way or another?
I know some things. I don't know others. I didn't lead the investigation. I assisted.
As to the specific fact I
No, I
asked,
didn't even know you could do that.
Yeah.
if an officer made
There you
that
go.
call and determined it was not an investigative lead, do you know that or would you know that?
Not necessarily.
Okay, and in this case, do you know that?
No.
You were showed a picture that is defense exhibit, apologize, 76. Do you recall this?
Yes.
You recall that it was, I believe it was honed in and there's some garbage bags along the side of that
You don't seem to
particular
understand
building.
the responsibility
You
of the
see
job.
that?
Yes.
And you were asked whether that was something you personally had reviewed, I believe, correct?
Something to that extent.
Are you aware that in the context of this investigation that those garbage bags were the remains of marijuana grow? That they are potting soil and other remains from a marijuana grow?
I'm going to object on the grounds that, one, speculation, lack of foundation, as he already testified, he did not look at those bags, look in those. It's also an argumentative question.
Yeah.
Well, counsel brought it up.
Oh,
I didn't
shit,
open
she
the
did.
store. He's either aware that that's what the contents of the bag are or not. That would lead
You were
a
doing that
reasonable
purely
person
so
to
you can
decide,
score a
is
point and
this
say
an
that he had
investigative
drugs.
lead about a missing body. If it's bags of potting soil for marijuana, then it would be reasonable to conclude that's not that's not necessary in terms of this investigation.
You already argued that he doesn't know what was in the bag, so that's irrelevant.
And I didn't bring the bags up, they did.
You're asking him, you're
What the
asking
content
him.
of the bags are. Which he's already testified is that he doesn't know because he didn't
what
even notice
his
the bag.
awareness was?
Yeah, which is what they asked.
Well,
No, they didn't.
The investigation is an entire group of separate inquiries. And if
Yeah, Val, but I thought that was only in
having an
oh wait, I do have
adequate
StreamYard link to
investigation
this, don't I? Streamlabs. There you go.
also involves proper coordination
Yep.
of various reports and observations. So you're asking
is that
him
what
if
the
he
gangs and
is
stuff
aware.
were?
Right. Which is my redirect question to their specific cross-examination. I'm using the same phrasing. He's
No,
either
you're not.
aware of it or not. If he's unaware of it, obviously I would
I
have to
specifically
put in
asked
any
if he
affirmative
knew
evidence
that
of
the
it with
bags
some
were
other
there.
witness. But this
You're
is a
asking if
question
he
of whether he's
knows what the
aware,
contents was, and
because
was
if-
it this specific
because
contents?
the
That is full
the
of
topic I
shit.
assume what my redirect is directed at is if I am correct that these are marijuana potting soil bags, a quantity of them, then obviously they don't have an investigative lead quality here. And again,
That's
they
argumentative.
apologize, they brought it up. So
Now, the
Who the fuck
objection is
cares
the
if
same.
you put it up? You know that it's an argumentative
as to
question.
his awareness, the question is to his awareness.
Yes.
Okay, all right.
Yeah, go for it, dog. Anyone's free to message me on Twitter, Discord.
You were asked by
email, whatever.
the defense
I may or
on
may not get back to you.
cross-examination counsel on
Feel
whether
free.
there was any videotaping of the defendant cutting the carpet out of the van. Do you recall being asked that question? Whether there was any videotape available of him, of the defendant cutting the carpet from his van during this period of time? Or pictures, either
No
video or
photos.
pictures?
Yeah, and there was no photos.
Okay. Would you expect someone who is trying to remove blood evidence from their van to videotape themselves or take pictures of themselves during that process? Is that something you would expect?
I'm going to object. This question is tending towards argumentative.
They-
That's more like it.
Yeah.
Oh. I've got to get that audio effect when the Windows shuts down. Hang on.
You were asked whether on cross-examination, whether Anderson's home had any body parts at its location or any other blood evidence. Am I correct that the search warrants at Anderson's home were 2 days and 3 days after the time you believe that Mr. Gutierrez was murdered?
Yes.
Okay. And Do you have any specific reason to believe that at any point that Mr. Anderson either stored the body at his home or did any of the blood work at his own home? Do you have any reason to believe that?
No, we
Okay.
found nothing to suggest that.
And so, again, would a person having 48 hours to no longer be in possession of the body of Rosalio Gutierrez or of any of the blood evidence, would a person have enough time during that period of time to either not have that evidence at their home and also to dispose of that evidence? Is that a sufficient amount of time?
I'm going to object. This is beyond the scope of my cross-examination.
I'm sorry, they did what now, Barbara? Is that
And
over
it's
what I
also
think it is?
argumentative.
I, as to the first objection, as I think I commented the other day, I am always hesitant to limit an examination as not within the scope unless it's really things that ought to have been fully covered earlier. So I'm going to overrule you on that. On the fact that it's argumentative and speculative. Speculative.
I thought the argumentative objection is me being argumentative with a witness. I'm not aware of argumentative being that there being another form of argumentative. I thought it
There
meant
are
to be
two forms,
Dude, what
Okay.
you obviously don't
One is
understand about
arguing with the
objections could fill a
witness.
book.
which is really a lower, is a branch of things that ought to be taken
That'd
up
be
in
shocking.
argument. And the lawyer is simply attempting to have the witness testify in a way which is a substitute for the argument. That's really the principal problem with argumentative questions, but it could be both, but it's also speculative. I mean, I think your question is, and correct me if I'm wrong, I think your question is, how long does it take?
Yes, Laney.
to
It is bad,
dispose of
but
a
at the
human
same
body?
time,
or
Wouldn't
well,
blame you
not
for
how
it.
long, but can it be done in 48 hours before this search warrant is done?
Don't know.
Well,
I don't.
okay.
I've had lots of pathologists up here and who will probably have it before this day is, or before this case is done. Oh, no, we won't. No, not in this case. But that would be speculation as to how long it would take to dismember or otherwise dispose of a human body.
Well, I mean, I'm not aware of any specific evidence that there was a dismemberment. One can just bag up a human body and place it
Also
in a
true.
dumpster.
Also true.
Okay,
Well, but dismemberment might be the more efficient way to do it. I don't know.
possibly.
So go ahead. No, but the objection is sustained.
So you were asked whether you saw a picture of the defendant in a flannel shirt. Do you recall that?
Yes,
And when that picture, and you don't know when the date of that photo was.
I don't.
Your reason for focusing on that flannel shirt is you have multiple witnesses who told you that just hours before Rosalio Gutierrez is murdered, in your belief, that he's wearing that shirt. Is that correct?
I'm going to object again on argumented grounds and foundation. There's been no testimony as to what time it's believed that Mr. Gutierrez was murdered or went missing.
Well, the problem I'm stumbling on with the question is what the detective's belief is. As I say, this gets into the argumentative, the subject we were just talking about this is
I saw. Thanks, Bob.
really
It's
part
90
of
minutes, so I probably won't do it
your
in this stream,
argument
but
later in the
we'll
case.
get to that.
that is attempting to be extracted from the witness. And the witness, in order to respond, it seems to me has to employ a lot of speculation.
Well, he has a working theory as to when this occurred. And he is, remember that the flannel shirt is a focus of the search.
Right.
Okay. So the cross-examination question was, well, you're basing this just on 2 witnesses. You have no photo at the time. So it is redirect to say, well,
he's getting it all on the
you
record.
have 2 witnesses and they
It's not
are
that he doesn't
close
understand,
in
he's
time
getting it on
because
the
we have no
record.
photograph of him that day. They are close in time to your
He's basically
working
giving the
theory of
prosecution
when
to hang
Rosalio
themselves
Gutierrez
so
is
that he doesn't have
killed.
to worry about an appeal.
So that counters with his testimony that his basis of focusing on the flannel shirt is that multiple witnesses say just hours before Rosalio Gutierrez is murdered per his working theory, based
like
on
I said, he wants
electronic
it on the
evidence,
open record.
etc., that
Sidebar wouldn't necessarily
that
have it there.
they see him wearing this flannel shirt. So it's not remote in time, which is the suggestion of the cross. And so the redirect is to show that, not that it's true, right, but that he's been provided information that it is recent in time.
If I may respond.
All right.
Thank you. First, if the state wants to ask, do you have a theory about when Mr. Gutierrez went missing, then that's the proper question to ask to lay the foundation for this series of questions, not to ask a speculative, argumentative question without laying that foundation. I have not heard any testimony from detective about his theory of when Mr. Gutierrez went missing or was killed. So again, I maintain the objection.
Well, but
Counsel and Cross did not
has anyone seen Bingo lately?
ask any foundational questions in that regard either. Why would he have to explain the theory if he's simply indicating it's near in time?
Well, given the opening statement that was made by the defense,
Yep.
I think that the existence of a quote working theory unquote may be a line that you might want to pursue and could, but that's not entirely clear thus far. And number 2, the way it's being presented is, in my opinion, argumentative, and also it's speculative. The objection is sustained.
When were you told that the 2 witnesses who are your source that the flannel shirt was being worn, what was your understanding of the time that they indicated they last saw the defendant in the flannel shirt?
I believe it was around 4:00 Sunday.
Okay, Sunday is May 17th.
Yes.
And are you a person who has knowledge of the electronic evidence of this case, at least in the general sense?
I know some.
Okay. And is, on the same day, is Mr. Gutierrez believed, based on the electronic evidence and his absence of any more responses after, is he believed to have been killed at a time in the area of 10 p.m.?
I'm going to object. This is already extremely leading.
What do you would say that?
Between 9 and 10 p.m. on the same.
Wait a minute.
I apologize. I thought you said yes. I apologize.
Oh, I'm sorry. I said it seemed it was leading.
Okay, I'm on redirect.
Right.
Okay, so I'm trying to direct him to the place that the court asked me to. The only other avenue I would have to ask this question is to ask him to explain what time, when he is not the detective who formulates that.
The objection to a leading question is based upon the fact that it is suggestive of the answer. And the form of your question was suggestive of the answer.
What time period, in your knowledge, detective, is the time period where it appears that Rosalio Gutierrez has been murdered?
Between 9 and 10 on Sunday the 17th.
That's the same day as as you've indicated, around just before 5, that the 2 witnesses saw him in the same in a flannel shirt that seems to match the picture.
That
This guy's an
flannel shirt,
absolute
yes.
donkey's ass.
You were asked whether Michael Campbell had offered you information that on May 17th that his phone was at the home of Rosalio Gutierrez at some point. Do you remember being asked that question?
Yes.
And you knew that Michael Campbell was a friend of Rosalio Gutierrez.
Yes.
Did it cause you any concern that he did not, that his friend did not tell you that he had some contact with his residents on some period on May 17th?
No.
And are you aware, pursuant to this investigation, that contact that they're speaking about is actually at 1:45 a.m. when you have just indicated that your thoughts on this case is that it would be 20 hours later, 9 or 10 p.m., that Mr. Gutierrez is murdered? So it would be 20 hours earlier. Are you aware of that?
No.
You were shown a picture of the bedroom of Rosalio Gutierrez. Do you recall that
I'm
picture?
sure at this point we're about to find
Yes.
it.
And
You
that
can't ask any
picture
more questions.
had a window in the far side of it, correct?
Yes.
No.
Are you also
No.
aware that the reports in this case is that the slider that would face the street was also found open in this case?
Yeah. I don't know.
Oh, you don't know? Okay.
I'm sorry. The sliding
Sliding door.
door
Yeah.
in the living room.
Yeah.
I thought we were talking about the bedroom window.
I apologize. I meant the sliding door in the living room. Are you aware that that was found open?
That's what I was told. Yes.
The screen was closed?
Yes.
Okay. So
You
that
were
would be
told.
another logical
Excuse me?
method of entry, correct?
Madam
Yes.
Defense, why did you
Simpler
not
method of
jump
entry
on
than
that?
climbing in a window, correct?
Yeah.
The blinds were in no way disturbed that you saw in the picture, were they?
Not that I saw.
And did that picture include notes on it? I'll show you.
I believe on the pillow on
Yeah.
the bed.
I'll redirect you there.
Don't say a word until I've given you the photo in case it contradicts what you're
Judge,
about
if
to
I can
say.
have a sidebar on this issue of line of questioning.
He's not seriously gonna.
You probably are not, haven't had an opportunity to see all of my brewers pictures in the back. So why don't we take 5 minutes, we'll be able to do that. Opening day is coming. So please don't talk about the case during this very short break.
Very short break. Very short break, he says. Okay, well that's interesting. Well, look, for anyone else that is here, just so you're aware, I'm also following, obviously, quite closely what happened with the Ohio train derailment, particularly because we do have members in the chat that live in the area, as well as Mr. Mighty Meat himself, who attended at the scene to have a look at one point. Yeah, so apparently some shit's been happening. Apparently Norfolk Southern's brought in their own private security and haven't even actually been allowing local law enforcement into the area. There's like a 19-minute video on it, which I'm going to probably use as a Rumble exclusive. There she is. Hey, Cornpo. You got any comment on the situation? This is what 20 years of experience looks like. Yeah. Oh, it wasn't the... Oh, no, it was the other one. Thank you. That's right. It was a different train. Fucking moron. Private police with canine units and all. Yeah. So... No. So this is the one that happened a few weeks ago. At this point.
Position that the defense was noting here is
Yeah,
there is a piece of paper on the pillow on the bed that's a note from Mr. Gutierrez's daughter. The defense's position is
like
that the
unmarked cars and
contents of
everything.
that note are not relevant to this case. I could see the potential argument that the state would want to make by introducing that there's a note on the pillow if they're going to try to loop in that, oh, he must have not slept there then that night of when it was put there, that's fine. But the defense would object to going into what the note says based on the fact that it's not relevant. And the defense's position would be that the introduction of what's in that letter would be simply to garner sympathy
worries, Bob.
and appease to the emotions
Yeah, Eliza,
of the
she was
jury, which
talking
would
about
be
the Ohio
inappropriate.
stuff. But yes, if you want to catch the morning session, head over to Legal Vices if you haven't already.
I intend to just simply indicate the first thing that counsel said. I did not intend to ask about the contents of the note. I just intended to ask, is this a note
shit.
that
You were going to pull an inference
was
from
determined
it.
to be a note from the daughter? When was the daughter there? She was there Sunday into the afternoon. And that is a piece of evidence that the bed was never slept in after May 17th. So I didn't intend to go through the content. In fact, I'm not sure he'd be able to read the content of the note. So.
And I think too, I mean, there's no evidence if it's from the daughter or the son. So as far as who the note's from, I think too is irrelevant. I think if the state wants to say there's a letter on the pillow, that should be the extent of the inquiry.
It's signed.
Is it signed?
It's signed by the daughter. Yeah.
Well,
Do we know that it's signed by the
I'm not going to get
daughter?
in the content because I don't want her name to come up other than that it's the daughter. But again, I think it is another way to time this out. This is this is a exhibit introduced by the defense for this witness. So obviously we have other witnesses coming, but I think it's valid redirect.
well, here's the problem, and I'm not criticizing anybody. This case is coming in with an enormous amount of evidence, which ordinarily would be totally inadmissible. And you said it a moment ago when we first started talking about this, you referred to it as a note which has been determined to be from the daughter.
Mm-hmm.
So there's some more that we're not apparently going to get into, but it's an example of how things without any sponsorship are getting into the record. And it really is bothering me quite a bit. Now, I'm not saying anybody's done
Your
anything
Honor.
that isn't right, but
Oh yeah, there's been things that have come in that would otherwise be totally inadmissible.
sooner we can move into
There's no way that note should be applicable.
what would ordinarily be received as circumstantial evidence, the better. Apparently, this is not a problem which is going to torment us. So I'm not going to worry about it, but just make a timely objection if you think something's going on that oughtn't. Okay?
That
No.
was a backhand at the defense. He's basically saying she's
Can
not
we get
objecting
a
enough.
ruling though on the scope that the state can go into as it relates to that?
As I said before, I really can't pre-screen.
Understood. So I'll just
may not go into.
understood. I
objections
will
as they
then
come.
just renew the objection where I find appropriate.
Thought his purpose, I understood, was to demonstrate that.
I don't know why, but we don't have captions. I've already got them. If you have a look, it's already on.
Since,
And for
since
some
she
reason, they're
left,
just not
since
showing
the
up.
note was placed there.
Yeah.
Right.
Okay.
I mean, technically, we are watching someone watching. We're watching someone from Law and Crime watch Court TV stream. We've seen that before because it got paused and then it got buffering little signal and all that sort of thing. So they've turned the captions off on their screen, so I can't turn them on mine. Because I'm not. We're watching Law and Crime stream, which is not actually picking it up for some weird ass reason that I don't understand.
Didn't I veto a couple of them?
Might have broke it.
No, I didn't.
Maybe.
I should have.
Why does the chair look like a medieval torture device? I mean, look, a lot of the time the judges get to pick their own chairs. He may not have. That one may have come with the courtroom. Those bastards, Tardo. You're welcome.
What's that? Down on a contempt, yes.
Shall I proceed?
You please do.
Okay. Detective, I again ask you to Turn your attention to
Into the
Defense
microwave.
Exhibit 60. You've indicated previously that's the bedroom. Is that correct?
Correct.
Okay. And that there was no DNA,
Oh, look,
there
to be
was
honest,
no
if
blood
I didn't
evidence
think
that
that
you saw
Fox
at,
TV would strike
again,
me,
your
I'd go and do
opinion,
it through
in
their
this room.
streams
Is that right?
myself.
Not that I saw.
Conditions were
Unfortunately,
muddy.
when it's through their
and,
website, they've got their own terms of
rainy on
services
this
that
day.
don't
Is
apply
that
to
correct?
YouTube.
Yes.
Was there any evidence on the windowsill that you yourself noticed that somebody would have entered knowing that it's wet and rainy over the last several days?
Not that I saw, but I also can't say I examined it thoroughly either.
That's not something you focused on?
No.
Is there a
course not. Why would he?
pink note on the bedroom pillow in this depicted here?
Yes.
And is that a note appears to be the author appears, at least by the note, to be the daughter of Rosalio
I'm
Gutierrez?
going to object as far as foundation and speculation.
Well, I thought that's where
I thought
that's where we drew the line.
that was my impression.
Oh, you thought wrong. You know what thought? Thought he farted, but he shit himself.
The defense's position is that it's not relevant what the contents of the note are or who authored it.
I certainly remember the first part. I'm afraid I don't remember the second part of that. The remark that I made at the time was that it was again a question about the sponsorship.
No, look, if he's back to questioning the detective, I presume they're back in the room.
That was my understanding.
Okay.
And I don't want the name of the individual, but does the note appear to indicate an author?
Yes.
And is that is the author a person related to Rosalio Gutierrez?
His daughter.
His daughter. Okay. And is the note placed physically on a bedroom pillow?
Yes.
Are you aware of when last Rosalio's daughter was located at his apartment so she'd
You
have
really want me to have a
access
hat, don't you?
Yeah, she was
I
at
have
the
several, I
house
just don't
on
usually
the
wear them on
17th
stream.
Through the early afternoon-ish hour.
So that pillow had a note on it, and that daughter is under 10, correct?
Yes.
Okay. And she was last at the residence on the 17th in the afternoon.
Yep.
Slide it one way and pull it down. There you go.
See much better.
Oh yeah, that was some legal gymnastics there. Maybe the Binger move is really the Gravely move. Maybe.
Detective, what is your estimate on how many interviews you personally were involved in this case? What would be your general
Like
estimate?
what? What are you talking about? Everything's exactly the same as it always was.
25 or so.
And
Around.
and did that involve a number of people, wide variety of people from all those different directions in this case?
Yes.
And at any point that
I'm sorry, what?
you came upon something that was evidence that persons were involved somehow in the disappearance or murder of Rosalio Gutierrez.
Can't do it. The cork's
On
irritating
each
me.
of those occasions,
my line
did
of
you
sight.
pursue that evidence when it was apparent to you based on all those interviews?
If I didn't directly, I would pass it on to other detectives that would follow through with that.
Oh yes, Kaiser is on tonight talking cinema and culture war. That's exactly what it is. It's an anti-fly hat, anti-mosquito hat.
Question, John. Thank you.
Yes, thank you, Judge.
And here comes the recross.
I don't know if you want me to pull up the.
They didn't need to cut that. They're talking technicalities. Who's pulling up the exhibits and who's not. Don't go wasting your time. Also, thank you to the 28 of you still watching on Rumble. If 13 more of you could just hit that like button, though, I'd appreciate it, given that there's 28 watching and 15 thumbs up.
Thanks, Jessica.
Doing a quick prayer because he knows what's coming.
So the state had in redirect asked
Okay,
you
thank you.
about that there were portions of the van that had been selectively cleaned. The area under where the missing carpet is, that area, to your observation, had not been cleaned, correct?
I'm sorry, what area?
Where the metal is exposed, that there was dirt and other items that show that area had not been cleaned?
Objection. The removing of the carpet would be the cleaning.
Well, I'm asking if under the carpet was cleaned.
Irrelevant whether you've
It's
cleaned.
not, how is that irrelevant?
I don't think that's,
I don't want to preclude her examination.
I can re-ask it, that in
Please.
that area, sorry, Detective, in that area where
Shanniger.
the metal is showing where
Just
the
happy
carpet
that you
used
liked
to
it
be,
now.
there's a lot of dirt and other scraps indicating that that area hadn't been scrubbed clean, correct?
There is dirt and there is things over the metal.
Okay, thank you. I don't need Exhibit 263. Thank you, State. The state had asked you about the efforts that you observed in the minivan were concerning to you, and you had said that it was not normal, correct?
Correct.
Sorry, Jimmy.
But you'd agree there are plausible other explanations for why an individual cleans a work van, correct?
Look, there probably is. And
Sure,
that's
you could
reasonable
come
to
up with some.
And the state had asked you about the screen door being open. You said yes, but you were not the first officer on scene,
You're watching
correct?
a prostate exam in motion.
I was not the first officer, no.
So you wouldn't know how
God, it's
that
so
door
uncomfortable.
was observed when officers first responded.
Correct.
The state just now, the last question that it asked you had to deal with all the interviews that you had with people. So I want to kind of break that down a little bit. You spoke with Michael Campbell, correct?
Yes,
He was just a friend of Mr. Gutierrez.
correct.
You spoke to Eileen Knoll, correct?
Correct.
She was a friend of Mr. Gutierrez.
Right.
And they didn't provide you any investigatory leads, correct?
Correct.
You then spoke to Sadie Beecham, correct?
Yes,
And it was your prior testimony that she had immediately stated that she believed her ex, Zachariah Anderson, had something to do with it, correct?
yes,
So it was purely on her word.
And you followed up on that one, right?
yes,
All right. And you also spoke to Olivia Anderson, correct?
yes,
And that was in relationship to Mr. Anderson, correct?
Mr. Anderson.
yes,
It's got to be someone.
You
How is that not
interviewed
on-
Mr. Anderson himself, right?
yes,
And you interviewed Christine Remsburg, correct?
yes,
That was the girlfriend of Mr. Anderson.
correct.
So she only dealt with Mr. Anderson, right?
Yes,
And you interviewed, I'm probably going to butcher her name, but Casalina Remsburg,
I believe she went by Cassie, yes,
and that's Christine Remsburg's sister, correct?
correct.
Again, relating only to Mr. Anderson.
Yes,
And then you spoke with Andrew Schultz, correct?
correct.
That was a friend of Mr. Anderson's, correct?
Yes,
And then you spoke to Alex Wetzel,
yes.
again, a friend of Mr. Anderson's, correct?
I believe it was a cousin.
I'm
You
quite impressed with how
talked
he's
to
handling
him
this, actually.
only as it related to Mr. Anderson, though, correct?
Correct.
And then you spoke with an individual named Amber Stark.
Yes,
And she was the girlfriend of Alex Wetzel, correct?
Yes,
And that had to deal with confirming his whereabouts the weekend of May 17th through
Objection
May.
is to hearsay.
I'll rephrase the question, Judge. You spoke to her as it relates to your investigation of Mr. Anderson.
correct.
And then you met and interviewed Solomon Anderson, correct?
Correct.
And that's Mr. Anderson's brother.
Yes,
And then you interviewed Jennifer Libers, correct?
yes,
And that's Solomon Anderson's girlfriend, correct?
yes,
And then you interviewed Joshua Anderson, correct?
yes,
That's Mr. Anderson's other brother, correct?
yes,
And then you interviewed Zenith Anderson, that's Mr. Anderson's sister, correct?
correct.
Then you interviewed Stephen Lenz, correct?
Yes,
That's a friend of Mr. Anderson, correct?
yes, correct.
So who did you interview that provided you other investigatory leads other than Mr.
There it
Anderson?
I didn't say I found any.
I didn't say,
I didn't say I found any other ones.
No further
But did you
questions.
look for them?
Were you
Oh,
just
how
asked
could
whether
you waste
spoke to
that?
Umdeen Labora?
Yes, that's another one. Kim?
Was that included in the list you were just asked?
No,
Okay, so that's not a person related to Mr. Anderson, is it?
correct.
Okay. And when you spoke to Michael Campbell, he provided you information that Rosalio Gutierrez had given him that led you towards the defendant.
I'm going to object as far as hearsay. Also leading.
Judge, there's just been a whole series of people listed, and they said there are no investigative leads that you pursued. I'm suggesting there are investigative leads on certain ones, and I'm asking,
He's
again,
now-
using the identical list of people that they just talked about. I'm not required to only talk about whether he found any leads that don't involve Mr. Anderson.
Judge, if I may, the state asked him, oh, you interviewed a bunch of people and you followed all those investigative leads. I then went into all the people he talked about. I asked him about Michael Campbell. He answered it. Now he's trying to go into exactly the information that Mr. Campbell had allegedly provided. And additionally, if the state is going to make commentary about what he wants the witness to answer to, I'm going to ask that that be done outside the presence of the witness.
let's just, much of the evidence you're hearing throughout this case would ordinarily not be admissible under that big rule, the hearsay rule. When I was in law school,
Yeah, but in this case, we kind of needed it.
had a book very like this, and about a third of the entire book was about the hearsay rule. The hearsay rule is a very, very, very complicated rule. It has many
Please
exceptions,
say
things
something
that you
along the lines of
might
the
think
prosecution wants me to throw this rule out the window.
would qualify as hearsay. And hearsay is evidence of an assertion made by a person while the person was not in court, under oath, and subject to cross-examination, which is offered in evidence to prove the truth of the matter asserted. So it's not anything that somebody said who's not on the witness stand. Sometimes that's what it is. But sometimes, a lot of it
The
isn't
judge
really being
can
offered
put
to
a
prove the
time
truth
on
of
it,
the
like a limit on it.
assertion.
But I think in this
It's
case,
being
if he's
offered to
been
prove
lenient enough
something
with
else.
the hearsay stuff,
And
he
in
kind of
those
has to.
cases, it's not hearsay.
So,
Then if it is
direct.
hearsay, it's subject to a large number of exceptions from the hearsay rule. which even though the testimony is hearsay, an exception permits its receipt into evidence. And believe me, we could take months and talk about this.
Please don't.
But there are many times when hearsay does find its way into the court record. I've never seen a case in which so much hearsay has come in. And I'm not suggesting that it hasn't been proper or that the lawyers haven't
So that's where
used it properly, but you're hearing a lot of hearsay that would ordinarily not be brought in. The critical feature for almost all of it that you're hearing has been that it's not being offered to prove the truth of the underlying assertion. And we're at that point again now where I'm going to allow the witness to testify about what Mr. Campbell, what he claims Mr. Campbell said to him. And it's not being received for use to prove what Mr. Campbell is reported to have said is true. It's not being received for that purpose, and you're not to hear it for that purpose. It's being offered in response to the defense contention that the police investigation was deficient, and what the district attorney wants to show is that the police were investigating and did receive some information and then made a determination about whether it was
That's a
worthwhile
very good way of
pursuing.
putting it, Wintersaler. Most of this evidence is hearsay and has no official backing
is-
as actual evidence.
again,
Watching a
He's
dramatization
not the
like it was
final
on
judge
Law and
of
Order.
what's true and not true. It's just he has to make a judgment for purposes of his position about whether this is something worth pursuing.
Thank you to the 235 of
The
you.
burden of proof in the case is totally unchanged. And that is for the state to
What you
prove
missed was the DA
the
being a
charge
horse's
against
ass
the defendant,
and
charges against the defendant
the
beyond a
defense
reasonable
tearing
doubt.
this detective a new one.
And
She's done really well.
leads the officer decides to follow and those that he doesn't are really not relevant to that. And that all this evidence that is coming in that is ordinarily hearsay is being received just in response to the defense claim that the case wasn't properly investigated. And I might add,
Yes, he's addressing a jury.
my final comment is that the huge portion of the book about the hearsay rule, I can still remember the first sentence. There is nothing murkier in the law of evidence than the hearsay rule. So it's a very, very complicated rule, but I just
Your Honor,
want to
I
caution you
generally
in this
like
case
how you've been ruling.
that
This,
ultimately you must
I feel, is
rely
an issue.
on facts which are proved by the case and are proved by proper evidence and that are sponsored by the person who, generally sponsored by the person who's making that assertion, who's here and subject to cross-examination. I know I could have done a better job of this, but is there anyone who has any question about this? Okay, I'm going to overrule the objection and permit the question with that understanding.
So Detective, my question was,
I
I'm
wonder
not
if he's
asking
gonna
for the
take when
content,
when
but
she
was
objects to the
Michael
next
Campbell
question.
a person who provided information to law enforcement that would conclude, that would lead them to go to further their investigation of the defendant?
Yes.
Did Eileen Knoll, when questioned about what circumstances she was aware of and helpful on, able to, did that cause you and other law enforcement to further direct your investigation towards the defendant?
Yes.
Did Sadie Beecham, in her interview, give you factual circumstances and things to investigate consistent with the defendant being the person responsible for these crimes?
Yes.
Did the defendant's daughter, when interviewed, give you information, eyewitness information and witness information that would lead you to further investigate the defendant?
Yes.
Did Christine Remsburg, the defendant's girlfriend, provide you substantive information that would lead you to continue and further your investigation of the defendant?
Yes.
Did Kazi Remsburg,
None
her
of these
sister,
questions matter.
provide you information that was consistent with that as well?
Yes.
Did members of his family, of
Just
the
the
defendant's
9,
family,
20 plus 9.
provide some information that would direct you towards the defendant and continue your investigation focused on the defendant?
Yes.
Did Stephen Lentz, when interviewed, lead you to have additional information that would lead you towards the defendant?
Yes.
So all of those people, when you interviewed them, again, led you in terms of following evidence towards the defendant. Is that correct?
That's fine.
Yes.
None of that
Nothing else.
matters, though.
Those people that led you to information about Mr. Anderson, none of them provided any information that they saw Mr. Anderson at Mr. Gutierrez's apartment on May 17th, 2020, correct?
Objection, that's outside the scope of my question.
I think it's exactly in scope of his questioning.
Well, actually, as I've repeatedly said, I'm usually not too rigorous in the application of that rule, but we're getting close to the point where my rigor may return. So you can have an answer to this one.
Could you repeat, please?
That those individuals that the state just asked you whether the individuals you talked to gave you information that pointed you in Mr. Anderson's direction. Now I'm asking if any of those witnesses, or actually stating none of those witnesses provided you information that they saw Mr. Anderson at Mr. Gutierrez's apartment on May 17th, 2020. Correct?
Correct.
Nothing further.
Nothing on that specific question.
All right, you may step down.
No, you can't object to the donkey sound because the DA's a
my
horse's
I have
ass.
30 seconds just to talk to co-counsel and just inquire about the next.
Yes?
Oh, I just.
How many Brewers fans here? One? Two?
Some
There has
information
to
from
be
people
a,
who support and
embarrassment
back up
about
their
it.
friend and family member. Also pointing
Three, I
to the
think
person
I
they believe did
know.
the crime, for fuck's
Thoughts?
sake. Exactly. I don't know if he was the lead
Accusation?
investigator. Apparently, he was definitely the first investigator on the scene. And no, he gave next to no evidence that wasn't hearsay or otherwise circumstantial.
Sometimes there's a.
Like, nothing there was... Just take a go, drink. All right, let's burn through some of these, because we've got 3 super chats. Jimva likes her. She is savage. That she is.
I'll like the.
Short witness, we've conferred, this will be a very short witness. and
This
then
is
we have a
Wisconsin
stipulation to
probably
read,
had the victim
and
for
then we
dinner,
will close evidence.
long pork chops, and fleshy fajitas.
Thank you.
Yuck. But thank you for the super chat on
Is that accurate?
Yes.
Prosecutor is a ballsack. Yes, he is, Flux. DA's getting bent over and pegged hard. Yep. Going to take this opportunity, people. If anyone has rotated in and out, please remember to hit like and maybe just consider subscribing. Thank you to everybody that already has. Very much appreciate that. At this point, I may myself be having a 10K blowout by the time I get to the end of this trial. That'd be nice. Yeah, it's good that the judge goes through his rulings. I do appreciate that, frankly.
Raise your right hand, please. Do you solemnly swear the testimony you're about to give in this matter will be the truth? the
Dude,
whole
you'd hire the stenographer
But
as a
it's-
dominatrix.
yeah.
Just take it easy.
Please be seated.
Yes, this is being his boss.
Ms. Swanigan, could you please state your name for the record and spell it?
Sure.
Marissa Swanigan.
And if you subscribe,
M-A-R-I-S-A,
there's always a chance you'll get a free membership as well. We have some very generous people in chat.
Swanigan.
And are you currently employed in some way?
Yes,
And what in general do you do?
management.
I'm going to direct your attention all the way back to May of 2020. On May 17th of 2020, were you living at the Wood Creek
I can outdrink
Apartments,
Jeff.
specifically
He has yet to break my
3709
record.
15th Street, apartment 2B?
Yes,
And that apartment, was that on the first floor, second floor, or somewhere else?
the second floor.
So did you have a downstairs neighbor
There's always
directly
at least
below
one
you?
person that downvotes my videos. Don't take
And
a personal door.
did you know him in passing, just being essentially apartment mates?
Yes.
And did you know anything about his family situation in passing?
Just 2 kids that I would see in passing.
And were they young kids, probably 12 and under, let's say?
Yes.
Did you know if one boy, one girl, 2 boys?
1 boy, 1 girl.
Okay.
Okay. And do you recall having contact with
Hey,
law
Marty's in the chat.
enforcement
Hey, buddy.
on the
I know.
19th
Downvotes
of
count as much
May
as
of
upvotes. I don't really give a shit.
2020, where they asked you, did you hear or see anything on the days preceding that caused you some sort of concern from the downstairs apartment?
Yes.
This chick to me is
And
sort of like
what,
a
if anything,
Midwest
do you
halfway
recall
between Karen
telling
and
law
Superman.
enforcement about your observations that
I don't know if that's even
that they were
remotely
asking
accurate, but
about?
that's what it is in my head.
Just hearing loud banging, like against the wall.
And was this specifically on did you have a specific night that you had heard this?
It was a Sunday night.
So that would be May 17th?
Yes.
And when you heard this,
Apparently.
approximately what time was it, if you recall?
Between 10 and 11
And where were you in your apartment when you heard this noise coming from downstairs?
in my bedroom.
And at that time, were you living in a 1-bedroom apartment?
Yes.
And was your bedroom at the back end of your apartment, so all the way through?
Yes.
And based on where you were in your bedroom, could you tell in general where this banging noise was coming from?
Yes.
And how are you able to make that determination?
It wasn't coming, the sound wasn't coming directly from under me. It was more so further in front, but below me, if that makes sense.
And so in your knowing the layout of the apartment, what room of the apartment below you did you believe this banging to be coming from?
The living room.
And approximately how long do you remember
Come
this
on.
banging to have occurred on the 17th?
They
Between
better be
approximately
saving a
10 and
half-decent
11
witness.
About 5 minutes.
And at that time, did you hear any speaking
sweet.
or any sort of anything else, or just the banging?
Just the banging.
And in
To
your
blow me.
experience as a human being, did you have any sort of thought as to what that banging could be in your mind while you were in bed hearing it?
I initially thought maybe something that was really big might have fell, or if the kids were still there, that they were playing around and they knocked something over.
And you said the banging went on for approximately 5 minutes?
Yeah.
And then once that 5 minutes stopped, did you hear anything further?
No.
And obviously, hearing that banging, knowing that kids sometimes are downstairs, you didn't call 911 that night?
No.
But when asked about, had you heard anything in the days preceding the 19th of May, that's what you were able to tell officers?
Yes.
And you were
The
for
witness?
sure on it was Sunday night between approximately 10 and 11?
Yes.
Actually, she's a 15 in my book. Prosecutor, I'd need to see what she looks like in heels. Yeah. I mean, look, this is second chair, so I'm not 100% surprised, but I would have expected a little bit more.
I have nothing further. Thank you.
Thank you.
Are they
Good
serious?
afternoon.
Hi.
Hey, so just a couple of follow-up questions. This banging or the sound that you heard, you said in between 10 and 11. Do you remember if it was closer to 11? Do you have a more specific time?
I would say closer to 10, like a little after 10.
And when you spoke with law enforcement, do you remember telling them that you didn't see anyone or you didn't see any cars?
Yes.
Did you look out your bedroom window?
No.
Okay, so you were just staying in bed.
Yes.
Okay. And so all your observations was this sound.
Yes.
And prior to hearing this sound, I hate to go into your whole sleep schedule, but got to do it.
Actually, I didn't see one, but I would still probably be standing, honestly. I mean, they've
How
got the
long
mics
were
and
you
that
in
sort of
bed
thing,
prior to hearing that
but
sound?
maybe it's just how Schroeder runs his
Maybe
court.
2
I don't know.
hours.
Okay, and were you awake and in bed?
Yes.
Okay, and prior to hearing this banging sound, did you hear anything else suspicious?
No.
So you didn't hear any screams?
No.
You didn't hear anyone arguing?
No.
And I want to talk about the apartments in general. How long did you live there for?
About 3 years.
Okay. And clearly you could hear what had happened when you heard this banging, but in general, tell me about how private that apartment building is as far as being able to hear what's going on in your neighbor's apartment.
It's pretty quiet.
But can you hear things
It does look
coming
like the
from
court's
the
been rearranged
apartment
slightly. I'm not gonna lie, compared
across
to the
from you or
Rittenhouse
below
trial.
you?
It would have to be really loud, but if it wasn't, yes.
And so
Right back, guys.
after and you're sure that this was Sunday night?
Yes.
Okay. Did you hear anything the following day?
No.
Okay. Did you see anything the following day?
No.
And were you there the following day, or were you at work?
I was there.
Okay. All day?
I believe I went to work at 9 o'clock Monday night.
Okay. Do you remember telling law enforcement that you didn't hear any sounds of glass breaking?
Yes.
Okay. But you said that I'm just trying to really get what the sound was that you heard. I know it's hard. I know it was a while ago. And you previously described it as something falling off the wall. But is there any other way that you can describe this sound?
It sounded like just something big being forced against the wall.
Okay.
Well, see, I know that there was a podium because the defense stood
In
up
the living
during
room.
Yeah.
opening statements and then handed him the mic. So there has to be something there.
I don't have anything further.
No, nothing further. Thank you.
You may stick down, man. I think you folks have put in a full day, and it's a good time to stop.
Can we,
So-
Can we read the
can we read the
stipulation?
stipulation?
You may.
Okay. Council, we're prepared to read the stipulation.
Yes, I would like to read the first part.
Okay. Any of my copy? I'm happy to do that.
Okay, sure. Thank
Okay.
you. So cordial. We have a stipulation. I'm going to read the first part, Judge, and then the state will read the second part. The following are statements attributed to Lene J. Douglas, who is an unavailable witness in this matter at this time. The parties have stipulated that these two statements should be read in their entirety to the jury in place of testimony that Ms. Douglas would have made if she had been available. Officer Paul Chase on May 19th, 2020 reported, quote, "I did speak with Lene J. Douglas in number 2C," end quote. Quote, "Douglas told me that she thought that she heard an argument from apartment 1B yesterday, May 18th, 2020 afternoon around 13 hours. She knew that the subject in 1B had kids and did not think anything of it. Douglas went on to say that she did not see who was arguing," end quote.
Members of the jury, the second part of the stipulation is as follows. Lene Douglas telephone call on March 10th, 2022 with DA Mike Gravely and victim witness coordinator Heather Beasy. Ms. Douglas was asked about her verbal statement to Officer Chase, in which he had her saying that she had heard an argument in 1B on May 18th, 2020 at about 1 p.m. Ms. Douglas stated that she could not be correct. Stated that could not be correct because she was working with headphones on for her job from her back bedroom on Monday, May 18th at that time, and
her
would not have been
testimony is
able to
irrelevant.
hear anything. She stated the officer must have misunderstood what she told him. She stated that when she heard something concerning apartment 1B, she was in her main living room, comma, it would have been about 9 p.m. because she was watching TV. She stated that it was in the few days prior to May 19th, 2020, when she heard at approximately 9 p.m. a scream in the hallway by 1B. She described the scream as high, as if someone was in pain and surprised. She stated that she could not hear anything further, which surprised her because based on the original scream, she thought she might hear a call for help or something. That's the completion of the stipulation, and of course, this has been filed with the court. It's been provided to the court.
Right. Folks, again, when there's stipulation, that's something the parties agree as being the true fact. And so that's something that you should accept. And no further proof will be received or received to either prove or disprove what is agreed to. Any question about that? Okay, anything else?
No.
Okay, let's break
Whole
for
bunch
the
of
day.
irrelevant shit.
9 o'clock tomorrow morning. Please don't read, watch, or listen when you encounter the trial. Don't discuss the
Okay,
case
it's
even with
4:36 in
fellow
Wisconsin. He's
jurors
finished up about
or
25
members
minutes
of your
early.
household, and we'll see you
Don't
tomorrow.
bleed off just yet, guys. We do have two things that I want to bring up just quickly because they are important. Just want to wait until the court feed is done, and then we will move into a few other things. Okay, looks like they're done there. Okay, so two things. One, just been made aware that Dublin Airport has suspended flights due to illegal drone activity. There's some dispute over whether or not that involves American drones taking action against Russian assets. At 7:01 local time, Ryanair flight FR513 departing to Bristol took off, followed by an Iberia flight IB 3791 to Madrid. Though there's not been any official release regarding the flight's resumption at Dublin Airport. Confirmed that flight operations were resumed at 18:59 after a confirmed drone sighting. Suspected operations.
You're right.
1827.
Yep, I think that's a good idea.
So,
Yeah, that's a good time to.
one thing out of the way, and now on the other one.
All right, I have a number of observations on the Van Wheat testimony. Or offered testimony.
Here we go. Oh, cheers. Very much appreciate that. I don't think they do, Barb. I think it's that there were drones in the area that were causing disruption to the flight paths and whatnot, so they had to ground the plane.
The first observation that I want to make is I thought it was very clear from the argument that has been made here that there is no dispute as to the scientific basis for the methods and principles which were employed in this case, although there's dispute as to the qualifications of Officer Van Wee and the method in which he did his observations and analysis. But
Damn it.
I did not understand any dispute as to the basic science of it and the requirement for the admission of this type of testimony, as stated in 907.02 subsection 1, is that scientific, technical, or other specialized knowledge will assist the jury to understand or determine the fact and issue, that the expert witness testifying is qualified as an expert by knowledge, skill, experience, training, or education, that the expert testimony is based upon sufficient facts or data, that the expert testimony is the product of reliable principles and methods, and that the expert testimony has applied the principles and methods reliably to the facts of the case.
It's a damn good question.
And
Elena.
the
I'm not gonna
defense
lie.
objection states that the defendant maintains that Officer Van Wee's testimony regarding his observations and conclusions of the blood evidence is not admissible for the following reasons. One, that he is not qualified as an expert in the field of blood stain pattern analysis.
God, I
Second,
hope
that he
so.
does not comply. His report does not comply with industry standards and requirements. And third, that Officer Van Wee failed to reliably apply principles and methods and made substantial errors in his report. And the defense position is largely based on a report submitted by Dr. Marilyn Alice Tebbs Miller, and she has made a number of attacks on Officer Van Wee's performance in this case and the contents of his report. And then we discussed at some length the other day, and I pounced, as I frequently do, when Attorney Mueller started talking about standards and requirements, and I challenged that to basically according to whom, and I think the response was the Department of Justice. And I have to say, I haven't made an exhaustive search, but I haven't found these standards from the Department of Justice. I think I made pretty clear that I'm not familiar with any authority that I'm required to follow standards of the Department of Justice. I'm not familiar with any legal authority for the Department of Justice to proclaim or enforce standards on the state courts.
Yeah, no worries,
And,
Monica. What I might do is
I'm
a
not suggesting
makeup
that the
stream just to
Department
run
of
through the
Justice,
actual
may not have done so, but the Department of
background,
Justice
basically.
has done
So maybe
a
keep
lot
an eye
of
out for
things
that. Thank you for
that
subbing.
are in the courts right now, actually, and in the Supreme Court right now,
Hello?
as to the reliability and the legality. But even assuming that they've made suggestions as to what standards courts should apply, I'm
No worries.
not
Yeah.
familiar with any standards which I am required to employ. Certainly, I've not heard of any constitutional, under the federal constitution, that I would be required to do so. And I've not seen any that set the standard for state law. And in fact, both the United States Supreme Court, from the beginning of Daubert, and the state Supreme Court from the beginning of Wisconsin's use of Daubert, has, I think, have deliberately veered away from a course of imposing strict standards on trial judges, and to the point that, as I mentioned the other day, Judge Apremian's article, which is in whatever they call the Wisconsin lawyer now. I guess it's the Wisconsin lawyer. Comments on Professor Blanca's splendid primer on Daubert evidence. And the fact that said Wisconsin was a lax Daubert state.
Are you sure, or is that what we want you to believe?
It's in assessing what the appellate courts have demanded of the trial courts. And
Sorry, I hit the wrong button. I was
Judge
supposed to be
Premian has
snoring, but
not-
that was the bad snoring.
necessarily agreed with that. I think he's suggested that the individual state's laws
Look at the horse's ass. He's
in
half out of his
defined,
seat and ready to go home.
easy definition of what is a lax and what is a strict application. But so as I say, I think.
Thank me.
that,
Thank the
the
people that are
Miller made
generous enough to
reference
give me out.
Controlling, I think that was my word, controlling, but on the idea that these standards
It's true, but I'm not going to record myself.
are to be followed in order for the witness to be qualified. And I don't think there's any control.
Oh, don't forget, and the cops fucked up the
element in it.
investigation. They did barely any
She's
investigative work.
advocating
Can't forget
adherence
that.
to the standards of the organization to which she pays dues and belongs, and I think has been an officer. But why they would be
Yeah, but
preferred
I
to a
can't
lot of other
really
criteria.
criticize him for that.
And I mentioned the other day that I thought they were very firmly rooted
Fantastic.
in
Thank you for the sub. I
an
appreciate that.
academic approach. And for example, suggesting that to be qualified for this analysis that was done here, that the officer ought to have had a bachelor's degree and have taken a course in trigonometry. And I've been in this position for 40 years. I was district attorney.
We
in the
don't need your
district
resume,
office
Your
for
Honor.
6 years. And in private practice for, I think, 7. And
You think for 7?
I have had this type of testimony come up
Oh, well, there you go.
numerous times, most notably in a case called
$3,000 fine, 6
Perez,
months suspended.
which I won't
Okay.
get into. But
Well, there you go.
trigonometry was never part of my analysis. Now, I'm not saying it
Mhm.
wouldn't be an
You did
improvement
really well today.
of my analysis
that cop apart.
to apply some trigonometric principles. But first, I'd have to take trigonometry because I didn't.
Oh, look,
And I
even with my
suspect
legendary liver, I reckon that
many
it
of
might
my
result in
colleagues
alcohol poisoning.
in the judiciary would not have taken that course or those courses. And even a lesser number of police officers, including those who've done a lot of this work and we've relied upon for many, many years in the criminal courts, that would not be viewed as a prerequisite qualifying as an expert. I understand there were some substitute courses in that, but as a general statement, I did feel it was the viewpoint of these standards which, well, I think they appear to be a product of the academy, and they are biased in favor of an academic background for the examiner rather than an experiential background. And from what I've read on the topic in case law over the years, both from Wisconsin and from elsewhere, as a general statement, I think the vast majority of the persons who've qualified to give opinion in this subject, while many of them have taken academic programs and have degrees of various types, but it's very likely a experience-based science. And Professor Blinka gives the example.
Oh shit! I thought he was going to fall asleep then because he put his head down like this.
Tester who tests and distinguishes between 140 different perfumes from
How do we
experience
get on the
alone
perfumes?
by smelling them. And there's no way you could scour the world.
Liza, I've got no clue.
Even
He's gone around in
and
like,
you'd not find
circles.
someone with the credentials to do a better job than someone who's just been doing it for a long time. So I'm not saying no that the doctor is wrong about this, and she's trying well to try to move this into a more disciplined area. And certainly education is a component of that. When I say education, we get education a lot of ways. Sometimes just by failing. But so she's trying to get more standards and ensure that the people are having some good background in some other aspects of blood stain examination and opinion. But I don't think what she's advocating, what these standards, as they're referred to, suggest are prerequisites to admission of the testimony and analysis of someone who is otherwise knowledgeable. And I remember there was some of you may remember it, but I certainly do. When Daubert was adopted in Wisconsin, there was almost a panic. What's going to happen? And hearing two different presentations, one by Professor Blanca and the other by a judge from a magistrate judge from the Western District, whose name I have to apologize, I don't recall. And also a presentation by a judge from the Court of Appeals, who was a judge in Janesville and Paris now. I can't suddenly come up with it. Very knowledgeable judge. And they all gave basically the same message. There's not much change from what the rules were pre-Daubert. It's my own opinion, from having lived through that period and having tried cases under the pre-Daubert approach. There was a word for it that's widely used at the time. You don't hear it too much anymore. Since Daubert, there was a lot of junk science coming into the courts. And I heard things said on the witness stand that I think, you've got to be kidding me. But we had such loose standards in those days about who qualified as an
Holy crap,
expert
he's still going.
and what opinions those experts might convey.
Well, sure, I was going to come back and the place would have cleared
That's
out.
what was the driving force in the adoption of the Daubert rule in Wisconsin. But these very capable people with terrific federal experience.
Well, maybe this
who
will
had worked
teach you to
with
save
Daubert,
occasionally.
said it's not that there's not that big of a change, and there is no doubt in my mind that under pre-Daubert approach, Officer Van Wee would have qualified. There are only a few areas where I think the defense has scored some legitimate points, and I'll get to those. But in terms of the first 5 areas of the inquiry, whether it's really a science, whether it's verifiable. You made mention, Ms. Muller, of the peer review. And see, to me, the peer review referred more to the determination of whether this is really scientific evidence and had been tested, and that there were available statistics as much as possible for its reliability. Well, does anybody know, was the issue of the so-called shaken baby syndrome ever been resolved ultimately in the courts? You used to hear that. I used to go to judicial programs all the time, and we'd spend days on shaken baby syndrome. Only the last time I ever heard of it was a presentation with some very eminent scientists and lawyers, and the consensus was that there's no such thing. I haven't followed up on it since. I haven't had a case like that come in here since. I don't know if Daubert spelled the end of that or if it's still being pursued, but there were enormous amounts of money being taken from one pocket and put in another on the basis of those lawsuits. Same thing with the tire cases that the combo, is it combo case? And the breast implants and the needless suffering which was endured.
Did you just use the word breast implants?
Because of people being afraid, because of what in the end wasn't really accurate science. That was what I think the objective was, is to shoo that stuff out the door. And those peer review was part of that. Whether when you made a Daubert analysis, whether it was verifiable information or just somebody's theory. I had a person come in here.
Big brain judge. Well, hope to God someday I'll get to that stage.
And testify that when a person is driving an automobile and is going to turn right, that motorist will always initially start to turn left to set up for the turn. I was embarrassed to be submitting that case to that jury with that kind of information. But so that was, I think, what the Daubert rules were aimed at and have largely accomplished. But I have to say, having lived through now 10 years of Dauber, 10 plus. I haven't noticed the difference. I'm just seeing less.
Are you seriously telling me? We just listened to you go on for like 15, 20 minutes and you don't see any difference?
In terms of the what Professor Blinka refers to as, in his article, March 2011, Wisconsin lawyer. Well, at page 18, these three foundational elements, relevance, qualifications, and helpfulness,
It didn't work.
are the target of the rule. And under 907.02, the qualifications element should speak to the reliability of the witness's principles and methods and their application to the facts. He comments, experts sometimes, he's quoting, experts sometimes reach different conclusions based on competing versions of the fact. And that the rule is not intended to authorize a trial court to exclude an expert's testimony on the ground that the court believes one version of the facts and not the other. And I made reference to that on the first day we discussed it, that while I have a gatekeeper duty, this is not my decision to make. This is for the jury. Professor Blinken continues, there is no definitive list of reliability factors that must be applied in all cases, nor is there a hierarchy of factors that ranks them in order of preference or weight.
66,000
Which
people looking at the law
factors apply and how
and
they
crime
are
feed.
weighed are within the court's discretion. This is a much misunderstood aspect of the reliability standard. In Dauber, the Supreme Court discussed 5 non-exclusive factors in the context of scientific
Look,
evidence.
Rabbit, honestly, most legislation
6
and most
years
court
later,
decisions are
it quelled a circuit split
the cure to
when the
insomnia.
court clarified in Cumho attire that the reliability analysis also applied to non-scientific expert testimony. But he goes on.
Deb, I've lost all track. I can't remember what the
And,
original
on
question was.
page 5,
He said he was going to make
no,
comments on the
19,
way
page
that the
19.
hearsay was being used.
At point 2, whether the technique or theory has been subject to peer review and publication.
I'm sure that there was a
And,
full follow-on of this, but because I got up to take that call, I've lost the
I
chain of
don't think
causality and I
either
don't know
the
where he's
general
at.
technique or the theory are at issue here, and that they have been
Spence wants the
widely subject to peer
DA's
review.
blood expert
and
thrown out because I don't
publication.
think they can call someone who took a 40-hour
And,
course an expert. That's a damn
but
good way
there's-
to get it thrown out.
I don't think there's any question now. I shouldn't say any, because I'm aware that there is one case that's ongoing now that raises some issues about its reliability. But I won't get into that because I don't think it has anything to do with this case anyway. But and the Supreme Court said, moreover, Rule 702 is broad enough to permit testimony that is the product of competing principles or methods in the same field of expertise. Finally, the United States Supreme Court has
No, Alex, I just
expressly
really need to pee, and I thought he said he was going to be done
that the
20 minutes
trial
ago.
judge must have considerable leeway in making reliability determinations. Disputes among experts centers on the principles and methods. The focus must be on the principles and methods. Appellate courts give short shrift to trial judges who unduly focus on the witnesses' qualifications. The court is required to
You can hear the birds in the background.
make a
Yeah,
separate
it's
finding
daytime. It's
that the witness reliably applied otherwise reliable principles and methodology.
look, it's true, Patty. But he could have put all this in a submission that they could have then read.
Page 60, professor says, experience alone or experience in conjunction
Generally, no lawyer is
with
going to
other
interrupt a judge when
knowledge,
they're
skill,
like this.
training, or education may provide a sufficiently reliable basis. In certain fields, experience is the predominant, if not sole, basis for a great deal of reliable expert testimony. Getting
What are you saying, buddy?
into Dr. Yes, Miller's report. She's made some observations of this, about this case, the most glaring of which was brought up by Mr. Gravely the other day, that she, as I said, I thought she succumbed to what a lot of us do now in the computer age and just took an earlier report and made some modifications. Nothing wrong with that. Made some modifications and issued it, but at page 4 of her report, Exhibit 3 that you've offered for the defense, during my review of Officer Van Wee's report and the case materials, including crime scene photographs, autopsy reports, and forensic laboratory testing results, I was able to identify several blood stain pattern identification errors made by Officer Van Wee. Well, of course, there was no autopsy. So she's grossly misstated what was available for her in her critique in order to
Nope,
make
can't
her
hold it.
critique.
Put it back.
I've reviewing in reviewing Officer Van Wee's report, he has experience. I heard a former police official being interviewed on television last night. I think the individual was from New York, but while New York's problems get more publicity, its experience is repeated around the country. This person who was very high placed in the New York Police Department, if I'm right about the community, said, we can't get police officers anymore. It's been made into a very unpopular occupation. It's a dangerous position. Number one, it's dangerous just in doing that line of work. And I understand there was a police officer killed in Chicago again last night, one in Milwaukee a couple of weeks ago. And then these people have to
Don't even start with me,
make
Leafy 554.
life and death decisions in less than a second. There was one on trial in Milwaukee 5 or 6 years ago, and Attorney Smith used to be with Jerry Boyle. I can't think of his name. Jonathan Smith.
Yeah.
Defended him, and he had, there was a video of the incident, and there was no question. The district attorney didn't even claim that the officer's first shot, which was non-lethal, was legal. But in, I think, about 0.7 of a second, the officer took a second shot, which was fatal, and got criminally
Now I
charged
just need coffee.
for something that happened in less than a 1 second. It's a big disincentive to taking that kind of a job. So there are decreasing. I think the particular, I may have read this in a part of this in an article too, just this morning, of someone talking about the lack of applicants for police jobs and how we used to have 500. No, it was Chief Deputy Levin who retired the other day, and he said we used to have 200 people apply for these jobs, and now we have, I don't know if he said less than 50 or if he said 20, but that's the problem. So where do you get all these qualified examiners if you impose even stricter criteria for them to testify as experts in the court? So you not only have to, you already have a limited number of people applying for these jobs, much less than in years gone by. And then to go with everything else, and of course there are some officers who either make mistakes or in some cases worse, but some people will paint the entire profession with just awful accusations when they're just trying to do their jobs properly. So you have an already diminished number of applicants, and then to take those limited number that you have and say, in order to do this work that the police desperately need to have done, they have to have blood stain analysis done as part of their work. They have to employ only those who have completed trigonometry courses and have a
The quality was low.
degree of various academic stature. So that is not part of the calculus for me in determining who's qualified as an expert. And I think Officer Van Wee testified very capably about his experience, credentials. And yet the defense says at page 3 of its brief or its motion, the only qualifications the state claims is that he has experience as a police officer and completed a 40-hour course in bloodstain pattern analysis. Skipping. Additionally, a 40-hour course did not make someone an expert in the respective field of study. But there's no support for that claim. I didn't see any citation to any authority that one can't learn this particular
Occupation.
scientific analysis.
Close enough.
A 40-hour course. I'm not saying it can, but I'm satisfied with all of his credentials, all of his experience. He is shown to have sufficient experience to qualify as an expert. The defense characterizes at page 4 Marilyn T. Miller, a national expert on blood spatter. I don't know if she is or not. I never heard her name before. And there's no citation of that. And that's always, of course, something that isn't easily quantified anyway. There are, I'll still say, I don't care what anybody says about Willie Mays or Mike Trout. I'll still say that Henry Aaron was the greatest baseball player of all time. So, you know, that's just somebody's opinion. So I don't know who said she is a national expert on blood spatter analysis, but it did, and that's unsupported claimants. As far as I'm concerned, the defense quotes from her report about how he doesn't have the undergraduate degree with coursework and trigonometry, science-based coursework, and specifically laboratory work in biology, physics, and chemistry. I don't see where that's necessary to the job. I really don't. And in the event this ends up in a different court, taking a look at it, I don't know. I just don't see those as prerequisites. Documented mentorship program, those would all be positive and pluses. But in terms of the reality of the world in which we live, I do not embrace that claim. Not being certified with the International Association of Identification. That would not make a big difference to me.
At this point, I don't think he's going to throw the expert.
standards, so-called.
Judge, I'm sorry to interrupt, but
Oh.
I really need to use the restroom.
Oh, yeah, by all
So-
means, go ahead.
Okay.
No,
Or if,
I'm almost
if we
done, but
can-
I don't want you to wait. No, go.
I can wait if it's gonna be, if
No,
it's gonna be,
I would never
quick.
do that to someone.
I'm telling you, I can wait,
Well,
but I want to be sure that I'm
Sweetie,
not,
he's telling you that he's going to be a few more
I
minutes.
don't want to
Go
feel like
pee.
I'm rushing anyone here,
I
but,
don't feel rushed.
okay, so I can wait, but if it's gonna be like 20 more minutes, I probably will want to take a
Uh,
break.
let's do that, we'll compromise. You can stay and hold on and I'll finish up within 5 minutes.
Great, I appreciate it. Thank you, Judge.
But feel free to,
If I need to leave, I
Yeah,
will, and I'll
yeah.
leave John and Kirk here.
all right. These standards, they didn't even start assembling them until 2 years before this incident. So, now, there is something about Officer Van Wee that I do think the defense makes a good point. He's not going to be permitted to testify to what was and was not blood. Because
No,
he hasn't
he's got no
credentials for that.
expertise in it.
He can testify to what looked like blood.
It may well have been
Whatever
rust.
characteristics he wanted to see, which probably wouldn't be expert material anyway. And somebody who walks into a scene like this, a totally lay person, is perfectly capable of very quickly falling into discussing it in terms of it being, oh, there was blood all over. But he's not going to be able to characterize anything as blood, at least not on his own credentials.
Oh no, the camera's set to autofocus. I've got to change that, but I'll do it after the stream. Occasionally, it'll go just
And,
slightly in and out and
this
focus on the,
business
on the
about
mic
his-
instead.
His usage of the terms, the victim was attacked in the hallway outside his apartment door. The bloodstains indicate the violent attack continued. To the extent that that is prejudicially emotive, that's got to be controlled. This is not an exercise for him to advance a theory of how the crime happened. His job is to report what he saw and what he's qualified to report on is the pattern and the like. And I think I'm going to wrap it up with that. So that's the reason I gave the ruling that I did. And what did you have to say?
So he would be able to testify that it looks to him like blood based on his experience. There literally is no one at Kenosha Police Department
Talking to the mic alone.
dealt with things in
Yeah,
he's more than him.
I would expect someone with even a few months, definitely a few years on any police department, at least around here, to be able to say, use the word bludge with considerable reliance.
So he's allowed to express his opinion that it's blood. He's just not allowed to. He's not allowed
When
to.
he's
definitively
talking scientifically, no.
say one more time.
He can't do it scientifically, no.
No,
Similar to
he can
what we just
opine.
had
What,
Officer
we'll
Detective
work it out. I'm not worried about it.
Okay.
Um,
So I understand. Thank you.
Thank you.
Thank you, Judge.
What did I tell you, 9 o'clock?
9?
Yes.
Yeah.
You told the jury none. Yeah.
Okay, please don't read, watch, or listen to the account of the trial. And enjoy the evening.
Okay, so there we have it. So we'll be back at 9 o'clock tomorrow. Before everyone floods out, there's one other small thing that I want to talk about. Thank you to people that have sent me some interesting things on YouTube and whatnot. However, a big thing that I just want to specify. Where's it gone? Shit, where's it gone? I'm gonna have to pull it up out of Discord again. A friend of the channel, DeOrg and the Greenfellas, are still running their charity streamathon, which closes out on the 3rd of March, I believe. So they've got a goal of $5,000 raising money for Rare Disease Day. Karen Knight has a rare condition. So the Greenfellas are looking to raise awareness and money for the organization that Chris works with year-round to help others with his condition. Please help the streamathon as they wrap up this month. Now, I checked. I feel like one of these was going live soon.
Link.
They're
God
live
damn it,
now,
so we can
guys.
watch it.
They are live now, so you can certainly head over. And you know what? I might even see if I can dump into
What are we
it.
talking about here?
Okay. So, don't have to, don't have to give a lot. Don't need to do anything like that. You're welcome. But yes, get over there, have a look. If it's something that you feel you can give to, then do so. But looks like a good cause. It's Rare Disease Day, and not everything always gets the same attention. Not everything's considered sexy in the medical research industry, so some things are just not treated as well as others. But anyway, guys, thank you very much for joining into today's trial stream coverage. I'll be back here tomorrow afternoon after Vice's stream. Just so you're aware, Saturday there won't be a stream. I will be away, and unfortunately, I do not have the time to pre-record anything at this point in time. If that changes, I will try and pre-record something. In the meantime, guys, as always, stay healthy, wealthy, and wise. Remember, you are not a piece of shit. You could do contribute to society, even if all it is hitting that like button on this video, which I would very much appreciate. And just double check, see whether or not you're subscribed, because let's face it, Susan did love to take away subs. So, as always, guys, gonna love you and leave you, and
Fuck this shit, I'm out. Fuck this shit, I'm out. No thanks. Don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out. Fuck this shit, I'm out. Fuck this shit, I'm out.
Well, you know what? That works for me.
Don't mind
It's gonna take me a second.
I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit.
Look, which channel is that on?
Alright
I didn't get a good look.
I don't know what the fuck just happened, but
there
I
it is.
don't really care.
Oh, you don't have redirect on.
This shit, I'm out.
But what I'll do is I'll just put
This
it in the
shit,
chat
I'm out.
instead.
Fuck this.
I'm gonna turn that off. Where are we? Shit, I lost it. I'll copy the link and I'll put it in chat. Oh, I believe Gene already beat me to the punch. Nicely done, Gene. and that's the charity page there in chat. All right, guys. Catch you on the flip side.